Hi guys! How is everybody doing? It is day 167 of the YSL trial. Closing statements are done. So we've got some housekeeping this morning, and then the jury is going to come in to be read the jury instructions, and then deliberations will start. From what I know, it's not supposed to be, they said a late start. I don't know if they'll let the jury stay and deliberate late. And then they've got all day tomorrow. And then here in the United States, Thursday is Thanksgiving. So there's not going to be court. And these jurors might want to, tidy things up. Who knows? So it's anyone's guess how long deliberations may or may not take. I don't have answers for that. Just, it's just food for thought. It's just something we can speculate, but no one has a real answer there. We are starting about 8 minutes late, I think, is what's behind on this timer, but we'll get caught up. I do want to say thank you. Yesterday we had almost a 12-hour stream. We were 6 seconds shy of hitting 12 hours with the live stream for yesterday, and I've heard from other creators that at the 12-hour mark, YouTube might not archive live streams. So we got out just in the nick of time, and yesterday's stream is still available on YouTube. StreamYard actually only recorded 10 of the 12 hours, so that was weird. So I'm going to be missing a clip of Hilton's closing arguments. Can't clip that out separately. But I do want to give an extra thank you to the last 5 messages I blurted out at the end of the stream yesterday. It felt icky to do that. But I want to give a thank you to One Happy White Girl, Orlando Antonio, Lucia M., and STS. I ran through your guys' supers right at the end, and I'm sorry that we didn't get to give them the attention that, your thoughts are important, and it felt really icky to get out of the stream that way. So, big thank you to you guys that have supported the channel, and anyone for hanging out for 12 hours yesterday. So, that was a whole time. Yes, exactly 6 seconds. You can go look at the timestamp. 11 hours, 59 minutes, and 54 seconds. So, that was a cool first. Very happy to do that with you guys here. And starting off today, thank you, Mike the Mob, saying good morning, Kat and y'all. We're going to get started. I saw STS also mentioned that Hilton got the bike border story wrong. And I think it's cool that people are catching that. I only caught it because Adam Scott had tweeted it out. And look at this, guys. Look at this. Look at this bigger. Now, what I'm saying with the bike story is this thing that Hilton started her closing arguments with. And what makes it interesting is, where did she say she heard this story? She said, my friend. It was her friend that told her. Just a friend. But look at this story. This is posted by byu.edu under a jokes category up here. Juan comes up to the Mexican border on his bicycle. He has 2 large bags over his shoulders. The guard stops him and says, "What's in the bags?" "Sand," answered Juan. The guard says, "We'll just see about that. Get off the bike." The guard takes the bags and rips them apart. He empties them out and finds nothing in them but sand. He detains Juan overnight and has the sand analyzed, only to discover that there is nothing but pure sand in the bags. The guard releases Juan, puts the sand into the new bags, hefts them onto the man's shoulders, and lets him cross the border. A week later, the same thing happens. The guard asks, "What have you got?" "Sand," says Juan. The guard does his thorough examination and discovers that the bags contain nothing but sand. He gives the sand back to Juan, and Juan crosses the border on his bicycle. This sequence of events, if repeated every day for 3 years, finally Juan doesn't show up one day, and the guard meets him in a cantina in Mexico. "Hey, buddy," says the guard, "I know you're smuggling something. It's driving me crazy. It's all I think about. I can't sleep. Just between you and me, what are you smuggling?" And there's a question mark. It's cut off. And then it's cut off here. Juan sips his beer and says, look, I don't know. So I didn't realize that last part was cut off. Let's see if we can find the last thing. And the thing is, it'd be one thing if you get up on the stand and say, "Here's a quote I really like," or "Here's a story or an anecdote that I'd like to talk about before we get into this." But Hilton just says this is her friend's story. Her friend that told her their story. Her friend that's a border patrol officer that told her a story. All right, let's see. Border smuggler. Aha! And then what are you smuggling? Juan sips his beer and says bicycles. So that's the end of the punchline. Thank you, chat. You guys are on it. But it's Why would you get up there and tell this jury that your friend told you this story while they were working as a border patrol officer? It's a joke. It's a joke. Why not get up there and say, there's a kind of well-known joke about distractions. Here's how it goes. Anyway, that's my whole spiel. That's my spiel. We're gonna get into this. Let's see what housekeeping they can do before they get the jury here. Also, cool YouTube update. It's been available on mobile, but it's now on desktop. You may have noticed you can get real granular with the playback speed. They finally added this custom toggle. So rather than 1, 1.25, 1.5, we could do like 1.4, 1.35. Isn't that cool? I like that a lot. So when we vote on a speed to play this at, you guys can be a little more specific if you like. Really, really cool feature. So let's get into this. It's going to help us get caught up. If it's too fast, just let me know.
Okay, we need to make sure we have taken care of all of our last minute housekeeping on the indictment, the verdict forms, the charges. Ms. Hirschfield shared an email yesterday evening that has what we think are the last things we need to take a look at. So if we want to just walk through those. I guess maybe the verdict forms are the easiest thing to look at first. And y'all just let me know if those look okay.
You're looking at the email that says final doc?
Yes, final docs, charges, et cetera, from about 6 yesterday evening. And it attaches each verdict form, the redacted indictment, which we definitely need to still address some things on. And then the jury charges may change based on what we do with the indictment. So let's just look at the verdict forms first. And hopefully those are actually in final form.
This is minor, Your Honor, but do we need an entire page for the
Well,
overt acts, or is that just a
Here's
good way
the
to break
thing
it?
is I thought about doing some lines, but then I didn't want y'all saying, well, if you put 10 lines, that implies that they should find lots of acts. So I thought if we have a blank page, it is literally a blank slate, and they can put nothing, 173, it'll be up to them. So that was my thinking.
Well, I certainly prefer that to the lines, so,
Okay.
but it's
All
very
right.
difficult to please us.
All right, then that's why it's there.
Well, Your Honor, as you know, the state would prefer the lines, but given that you made it clear, you sort of made your mind up on this issue, I think that this is the most appropriate middle ground. The way it was before implied that there would be very few or any. And this is, as you said, it's a blank space.
Okay. All right. So any other items? All right.
And I don't know if it's the same thing as the Sharp's thing. On Mr. Stillwell's verdict form.
Yep.
For count 49 and count 52, just for consistency, I would put the not guilty first and then a guilty.
I agree. Don't know how that one happened. Ms. Persfield, can you switch those around? Thank you for that catch.
Your Honor, I'm going to object on count 2 and count 49.
Yes.
I don't think you should be putting the victims' names.
Why?
Well,
I mean, if you're going to object, you need to give me a reason.
because, I mean, I think it's clear what the 2 counts are. If we put a date on it, I wouldn't necessarily have a problem with it. I mean, I think it's clear that my client's charged with 2 murders. I don't think it's necessary to put the victims' names next to each count.
All right, well, I appreciate that objection. I overrule it. All right, anything else on Mr. Stillwell's verdict form? All right, hearing nothing, we will move on to Mr. Kendrick's verdict form. And it's possible that then, I don't know if we have a guilty, not guilty reversal on that one, but if
No,
we do, we'll
it's
fix
correct on that one.
Okay.
Or consistent. Use
consistent.
that word,
Okay.
consistent, Your Honor.
All right, anybody have any issues then on that verdict form? I guess maybe you could on the, I don't know why it's not showing up on mine. I don't have lines under this blank day of blank, but it looks like you do on yours, Ms. Persfield, so as long as they're there. Okay, all right, so looks like at least the verdict forms are in their final form.
Found? Weird.
the redacted indictment, and as y'all can see, and from the email, I determined that Overt Act number 175 shouldn't be in there because it seems to not assert one of the necessary elements to have made that a crime.
Yes, Your Honor. I understand the thinking behind it, but I don't think that's consistent with Georgia law. I think we've already established, and the court has recognized, an overt act doesn't have to be a crime, and therefore we would not have to have all the elements present.
You are asserting the crime of, did commit the felony offense of whatever, OCGA, section whatever, so,
That was the first part of my argument. The second
okay.
Second part is this, under Georgia law, and federal law is consistent as well, the state does not have to allege all of the elements of an overt act that does happen to be a crime because it is not separately charged. The pleading rules are not the same. You can't generally demur to an overt act. And so while it might not be adequate as a freestanding charge, as an overt act telling the jury what we are saying was done, that would still be sufficient. They don't have to decide it's a crime. They just have to decide it's an act in furtherance of the conspiracy, because they're not separately convicted of that.
I don't agree. If you have law that is on point, show it to me, but if you are asserting he committed the felony offense of possession of a firearm by a convicted felon, previously convicted of a felony involving the use or possession of a firearm, and you cite 1611-133, one of the essential elements of that is that he's possessing it while he's committing a crime. And y'all don't assert that.
I understand, Your Honor. As far as it not needing to be a crime, Yates versus United States, 354 U.S. 298.
That says if you assert it as a crime inside a statute, it still doesn't have to be a crime? I know an overt act doesn't have to be a crime. Are you saying that Yates is going to tell me that if you assert he committed X crime, you don't have to actually be asserting a crime, even though you're saying pursuant to XYZ statute?
So I'm citing Yates for the initial principle.
That I understand.
Okay. I'm not representing to the court that Yates says all of the additional things you said. I don't have a cite off the top of my head, so I'll simply have to represent this to the court. But I will tell you that it is well-established federal case law, for example, that if a defendant is charged, let's say count one is conspiracy, and there is an alleged overt act, that overt act is also alleged as count two, independently.
Right.
The defendant can be acquitted of count two because the jury finds an element of that separate charge was not found, but it still functions as an overt act in furtherance of conspiracy, especially when, like the ones we're talking about here, there's more than one actor involved.
There's not here for 175, there's only Mr. Nichols.
Okay, all right. I still don't.
All right, again, if you find some law that is on point, you let me know.
All right.
By that reasoning,
If you find some law, we'll deal with it further. Otherwise, let's move
I
on.
agree, I'm with the court,
Okay.
but I'm wondering if that should also not apply to 174, 189, 190.
So on those, I would like to know, let's see. Good question. All right, 174 and which others?
189, I'm sorry, go ahead.
189 and 190.
I think those present the same situation. Yeah, I think you're correct.
I just put the indictment in the chat if anybody wants to look at it as they go through this stuff. The light buzzing is a good time.
So looking
today.
at, like, for instance, on Mr. Stillwell's March 17th possession of a firearm allegation, it's also a substantive count 64, and it's saying that he did that on March 17th, and we know from the evidence that what everybody is talking about is the gun that was, I don't know if it was thrown out of the car, but the gun that was discarded during the chase.
The gun or guns?
And, you know, I mean, I think we were looking at sort of the somewhat odd language of 1611-133.
Right. And so I guess my stance, Your Honor, is that ultimately, when it comes down to it, the state did not indict this correctly, and the state did not put it in the overt acts correctly, and they specifically alleged a specific crime in the overt acts. So we moved for a directed verdict on the substantive charges, and Mr. Abate and the state provided case law that saved that and opened up the possibility for a lesser included, and I get that. But I don't see that same mechanism of saving the charge for overt acts.
Right.
And so that's kind of where we're at. Essentially, I'm suggesting that there should be a directed verdict on the overt acts.
Yeah, I mean, I think those overt acts need to be removed. 174, 175, 189, and 190.
That's a good
Your Honor,
win
may the
for
state
the
briefly
defense.
address that issue? The state does believe that for the reasons that Mr. Floyd was just articulating about the case law for a substantive count of 133, as the court, as we have addressed, you can have the possession of firearm by convicted felon because it's a lesser included. Legally speaking, the argument for an overt act language, which does not have to have as much specificity as a count that the jury is deliberating on. The first language in 190, for example, is possession of firearm by convicted felon. It obviously has the superfluous language because it's not completed of the underlying felony, but that same logic for a count, which has to be more perfected than overt acts do, because overt acts do not have to be crimes.
But I understand they don't have to be crimes,
Yes,
but they've
Your
been alleged to be crimes with specific statute numbers. And yet y'all haven't included what would be essential to make them a crime. So are you arguing that the overt acts should be lesser included also, or what are you saying? What's your argument?
Your Honor, my argument is that if the jury is tasked to decide if on March 17, 2022, when Shannon Stillwell possessed the firearm by a convicted felon in furtherance
Previously convicted of a felony involving use or possession of a firearm.
Yes, Your Honor. That in the state's mind, the lesser included argument on a substantive count is a harder standard to meet than an overt act. There's no such thing as like a directed verdict on an overt act as there is with substantive counts. And so the state believes that same legal principle of why lesser included of possession of firearm by a convicted felon can be included on a substantive count is even stronger on an overt act.
So are you, so I'm
Yes,
clear,
Your Honor.
are you asking that these be converted into just possession of a firearm by a convicted felon in the overt acts? As
Essentially,
kind of a lesser included crime?
yes, Your Honor. And if the state, or if you, like, for example, if the state, from my understanding, were just to, redact, or essentially, yes, Your Honor.
All right.
And I'll let Mr. Floyd.
I mean, I think that there is evidence presented for that. It's, and I hope y'all understand what my thinking is on the, because 133 requires that it be asserted that they did this while they were attempting or committing a series of crimes listed or types of crimes listed in the statute. And that is in nowhere listed in your overt act. That seems to be problematic. But simple, if you will, possession of a firearm by a convicted felon, you don't have to be possessing it while committing a crime. You just have to be possessing it. And that has been asserted in each of these overt acts.
Well, and Your Honor, just to supplement what my colleague, Mr. Atkins, was saying, I'm holding this up because I've been informed they can't hear me behind otherwise. The point, this does different work as an overt act than it would as a separate substantive charge. Frankly, only the fact, just the fact that he had the gun during the course of the conspiracy is enough for it to be an overt act. It just, he is in possession of a weapon.
I know,
The
y'all
rest of the
didn't
details.
allege it that way.
Well, that may be so, but it still does the work under it. I mean, it wouldn't,
They cannot return, I find overt act 190. He committed this crime when you have not asserted that every element of that crime. They can't possibly find that when it hasn't been correctly asserted. Y'all have left out an element. So unless you've got case law, you're not going to convince me on that one. We have moved on to whether it should be redacted, modified to essentially assert a section 131 crime of simple possession of a firearm by a convicted felon. And I think that has been sufficiently asserted in each of these overt acts.
Excuse me, and the
Yes.
state may be able to find a case, but I haven't, I mean, and you may be aware of a case, Your Honor, and in my limited time, I haven't found one, but I don't believe that there's a case that permits the court to go back
I do
and
not
fix.
have any idea whether there is.
Yeah, I do not believe that you can go back now and fix the error that they have made, or whatever, fix what they have done at this point in time by modifying the allegation
Yeah.
of this overt act. At this point, I just don't think you can do that. I think
I
the
don't
only
know.
option is to redact it, Your Honor, and it would be, I think it would be error to go ahead and change that.
I don't know. So
Because that's what we have been,
I'm sure we'll have some time between now and when we actually send it out for somebody to do some research on that. So we'll put a pin in overt acts 174, 175, 189, and 190. They're absolutely not going to be included as a 133 offense. Y'all can let me know if there is case law out there that answers our question on the floor right now of whether they could be converted into a 131 offense, since it at least asserts that. But I don't know whether we can change it like that. So we'll come back to that.
Just so it's clear, do you want specific law subject to the part of what was provided last week that would allow?
Yeah, because we need it specific to, can an overt act, in the midst of a trial after the evidence has been closed, be modified to assert what would be a lesser included crime that is fully alleged in that overt act. All right. So our next issue let me jot myself a note down. All right, the overt acts that include Mr. Kendrick and others that I granted a directed verdict as to Mr. Kendrick that basically with regard to the possession of cocaine and possession of codeine. And that's easy enough to redact out of the substantive count of the indictment itself, although we need to actually look at, if y'all can open up then, what count is that, Ms. Persfield? I'm sorry, the count. We'll do the substantive count first. I think it's highlighted. Okay. If y'all will look at count 57, the issue, I would just strike possession of codeine with intent to distribute and possession of cocaine out of the indictment. I know that it doesn't really matter with regard to Arnold and Williams. I mean, they're on this indictment, but they're not deliberating about them. So it really doesn't matter, I don't think, whether something that those people could be charged with is included or not, because all that the jury is deciding is Mr. Kendrick. So is everybody okay with us just redacting out possession of codeine with intent to distribute and possession of cocaine on the substantive count?
I'm okay with that, Your Honor.
Okay, all right. Now, the somewhat more complicated issue is when we go back to the overt acts, because those are, that same thing is essentially included as an overt act as well, and those start around overt act 183.
And on that, if I may just briefly speak to that, Your Honor. I mean, we have a similar situation, I guess, that we're fighting with those others, and that the question is, do you redact the entire count, right?
And I think not, because with an overt act, it doesn't have to be that Mr. Kendrick was the one that the jury determines whether or not committed. The other people, they could think, well, Mr. Williams possessed that codeine, so.
But here's the problem with that. Let's say they come back in the jury verdict form and they list 183 as one of the overt acts that they find, right? We don't know if they found that because they found that Mr. Kendrick.
Agreed. So here's a possibility.
All right.
So I'm going to throw this out here and y'all can let me know what you think. If we have a 183 that alleges that the three people that are included, Arnold, Kendrick, and Williams, possessed marijuana with intent to distribute and a firearm during the commission of a felony, because those are still live with regard to Mr. Kendrick, and then maybe a 183A that says, you know, or posits that Arnold and Williams possessed the codeine and the cocaine. And then we know, okay, it's 183. They think they all, or somebody at least, possessed those two things. Or we think maybe Mr. Williams or maybe Mr. Arnold possessed the codeine or the cocaine, but we know it can't have been Mr. Kendrick because I've already determined that.
So just want to make sure I understand the court's suggestion. There'd be essentially I'm going to do a slightly different numbering system. There'd be a 183A, which has all three individuals listed, but you would remove the codeine and the cocaine. And then there would be a 183B, which would just be Arnold and Williams with the
codeine and the cocaine. Yes, that's what I'm proposing.
My only question with that is, are we facing the same situation, or with a question of, can we then go and modify? I guess we can modify these overt acts. I don't know if we can modify.
Like that's an easier question because it's based on me having directed a verdict that Mr. Kendrick can't have done those two things, so it inures to his benefit.
I'm willing to go with your suggestion as long as it's not taken by the court or anyone else, that I'm conceding that the ability to modify this overt act for A and B due to a directed verdict is a concession that you can modify those other overt acts that we referred to earlier.
Understood. And if we find out that you in no way can modify, then I guess our solution would be to just strike those two things entirely. But I don't think that is actually fair to the state when it could be that, you know, they asserted that all three of them did that, and it could be that the jury thinks one of them did that.
Yeah, and I'm not, while I probably should, I'm not disagreeing with the court on what you're saying with respect to that. The real key is going to be if we can find any law and what that law says.
Sure.
That'll be determinative of some of
And
those issues.
you say I probably should, but you shouldn't if you, well,
I do.
I appreciate that you take your duty of candor seriously. I really do. Thank you. Yes, sir.
Your Honor, with regard to Act 183,
Yeah,
if the jury unanimously finds that this overt act was in furtherance of the conspiracy,
yeah.
I believe with the instructions the court will be giving, when you have multiple parties, you know, and could mean, you know, and can be or in pleadings. And so if the jury finds that this, which includes Mr. Arnold, Mr. Williams, and Mr. Kendrick, if they find it's an act in furtherance of the conspiracy, it would be attributable against Kendrick and Stillwell. So I believe the state's current belief is that the way it is worded is safe with the instructions the court will be given about possession, constructive, actual, how you read and in indictments or pleadings, so that the jury, who's presumed to follow the court's instructions, will use those legal principles. And if they do find this overt act is in furtherance, it will be following that law.
Here's the
Yes,
challenge with that, and just kind of think through this hypothetical with me. We have got overt act 183 that says Arnold, Kendrick, and Williams. Let's assume that the only overt act the jury comes back with is 183. And all we know is they found 183. But how do we know then that they didn't say, you know what, I think Mr. Kendrick possessed codeine with intent to distribute. That is all I think, and that is why I'm finding this count. When I have already directed a verdict against the state and on the side of Mr. Kendrick with regard to that, that seems problematic. And then the whole case gets reversed, assuming that that's what happens.
Understood,
And
Your
I,
Honor.
I doubt if that's going to come to fruition, but legally speaking, that's my worry with leaving it the way it is.
Understood, Your Honor. I'm thinking through it with the court
Yeah.
right now.
Okay.
So if we could come back to this.
All right.
Thank you, Your Honor.
I guess what does make sense is we didn't have to charge the separate offenses. We could have just put those offenses like we did in the overt act, and your directed verdict on those obviously would have no.
That's true.
count, because there's no directed verdict.
That's true, but I'm worried about an inconsistent verdict, which is not allowed.
Well, inconsistent verdicts in Georgia are not. Georgia doesn't have inconsistent verdicts. They don't go.
Well, what is it that we phrase it? It's not inconsistent. What is it called? Repugnant. And I don't know, this would qualify as that, but it's factually, I don't know the answer.
Your Honor,
I just know the question.
I think we'll have time to return to this.
Okay.
I'd like to bring you, bring you some authority. But
Okay.
I can tell you that my understanding under analogous federal law is that there is not such a thing as an inconsistent verdict as between a substantive count on a charge and that being an overt act. The jury could find it to be the overt act, even though the substantive count they rejected explicitly.
Okay, but that's not them, all right. If you can, I think that would be an inconsistent verdict, which wouldn't be problematic. Our situation is not that. Let's assume that nobody else is charged, that it's just Mr. Kendrick who is alleged to have done overt act 183. And I have directed, and it's only, Cody, and I've directed a verdict on that count with regard to the substantive count.
Yep.
Could we then leave that overt act in? When I've said as a matter of law?
Actually, I believe the answer.
So that's our question.
Right, understood. It helps to frame the question.
Okay,
And we're going to come back and talk about it, so I don't want to.
all right.
I'd like to be.
Think
better
it through
informed.
before we know what the case law
Make
is.
better use of my time.
Okay.
Thank you.
Appreciate it. All right, the next thing is on the overt acts that allege possession of a firearm by a convicted felon that aren't also substantive counts. We were adding definitions of, like, if, I don't know, Mr. Arnold was alleged to have committed an overt act of possession of a firearm by a convicted felon while he was convicted of, I don't know, dealing in some kind of drugs. And we would need to have defined what is that underlying crime in our overt acts definitions. But that would only be true, I think, if we then had, well, let's not have it be Mr. Arnold. I'm talking about Mr. Kendrick and Mr. Stillwell. They've been alleged to have been convicted felons based on convictions for gang act and burglary with regard to Mr. Stillwell, shoplifting and possession of dangerous drugs out of Arizona. As to Mr. Kendrick, I just want to make sure that those convictions are in evidence. And that ought to be easy enough to check. And honestly, I think, Ms. Hilton, you maybe even cited what the exhibit numbers were. I just want to make sure that is what those matched up to.
Yes, Your Honor.
So I think it was, what you said was 60G, 30Q, and 487VV. So can we just pull those and, or if you've got it on this, you had it as a slide, actually. If you want to just pull that up too, and let's look.
And there are other convictions for Mr. Stillwell that were admitted as well.
Right, but I'm just, at this point, trying to figure out which crimes not otherwise defined do I need to define for purposes of overt acts. And we have not yet defined shoplifting, burglary, or whatever that Arizona dangerous drugs thing is. And I'm not even sure how to define that one, but looking at the indictment, plea, and sentence would help. And are we sure that was a felony shoplifting? Because shoplifting isn't always a felony. So can we just pull those convictions?
You want me to pull that, post it in the,
I mean, the actual
you want me to pull
piece
the
of evidence would be probably the easiest. Thanks.
Whisper, whisper, whisper. Also, big shout out, big thank you here to LaDonna Ames, gifting 5 memberships, which is super nice. I can't hear anything interesting. I'm trying to eavesdrop though. All right, so we're gonna try to move forward a little. Hopefully we don't skip anything.
And Your Honor, unless I missed it, I don't believe the Arizona conviction came into evidence.
Oh, were they trying to put that back with the jury?
If 438 VV, now you had cited in your closing presentation 487 VV.
It was 438 BB, which is this
Okay,
for.
all right. So it doesn't look like the Arizona conviction came in, so. Conviction, the intent to destroy. We're starting.
All right, so here's a little action.
All right, so we're starting with overt act number 3. Y'all allege that Mr. Stillwell possessed marijuana with intent to distribute on 8/23/13. Is there a conviction for that? In which one is that?
That is going to. Yes.
Hmm?
Well, no.
It's neither of these. Aren't there 3 for Mr. Stillwell?
Yes, Your Honor.
All right, you handed me 2.
I handed you the 2 that we discussed.
Okay, can you hand me all of the convictions for each of them that are in evidence? I just assumed that you had cited all of them in your closing, but that's okay. It's probably this one. No, this is a Tennessee. It can't be that one. It can't be that one either. All right, I think it's still somewhere in one of those bins, if it is in evidence. All right, Ms. Persfield, the burglary one, there is a conviction for, so we do need to define burglary in our overt acts.
Your Honor, for 2013 Act 3, we put up evidence of that.
Um,
I'm trying to see
2013 Act.
Act 3.
Okay,
Sergeant E. testified.
okay, all right, as long as there's, okay, so there's some evidence, okay.
Yes, Your Honor.
All right. Just a second, sorry. All right, and we've already defined possession of marijuana and to distribute anyway. Yes,
I don't think it's necessary to define the, I guess, the burglary for the example that you just referenced as it relates to that conviction. They just need to determine that what they have is a felony conviction and that they've been convicted of that felony. There's no added, I think we're just adding extra charges
Okay.
and confusion to the jury to have.
I see what you mean. That's a good point. If there's a conviction in there, then they don't need to make a determination whether that occurred. It's proven by the conviction. All right, that's reasonable. All right, so then 55. So are there other overt acts that have been proven by somebody else's conviction being admitted, such that we wouldn't have to define those either? Of Act 58. All right, y'all, overt Act 58 alleges possession of a firearm by a convicted felon by Mr. Kendrick, by possessing a firearm having been convicted of that Arizona felony. Is that conviction of possession of a firearm in evidence? Not the Arizona conviction, but the, I guess, I don't know if it's I assume Georgia conviction for possession of a firearm by a convicted felon?
That's the one that you have for 38B.
Okay.
That October 1st, the conviction for that October 1st crime is 438B.
That was confusing. But Doug's not objecting, so.
All right. All right, so.
Oh, my bad, Andrew. I was looking at the indictment, which I'll link again in the chat.
All right, let me give y'all back all of this. You can put it back where it goes. And then maybe I'll come up with any other overt acts where we won't need to define a crime because it's established by some alleged co-conspirator's conviction that's in evidence.
Your Honor, we are,
Gosh.
Your Honor, we're looking at that now, and I think the court just addressed this, but just with the Arizona conviction,
Yeah, we don't need that one. We just need the, yeah, that one's satisfied.
thank you, Your
Thanks.
Honor.
Oh no, Brittany. Nightmares of Hilton yelling. Oh no. Also, shout out to Aaron Grimmett, because, yeah, you did call this. The state's going to screw this up one time. I mean, we have the overt acts wrong for anything relating to that 16-11-133. They seem disorganized about which prior convictions they were relying on and whether or not they were actually admitted to the jury. And Thursday, Friday, when they were working with each other, they were supposed to sort all that stuff out. So they should have that, they should be clear on that by this point. But here we are. Here we are. Also, Asia, thank you for being a member here for 2 months. It's super awesome. Glad you're here. Chloe Albert's Revenge says today's theme is Shades of Turd. They sure did, like, change into this gradient line of drab colors after doing the powerful red yesterday. They double as a band, too. Oh boy, their song lyrics would be crazy.
Sorry, overt act 34 is Walter Murphy, possession of firearm Do we have, is that established by a conviction? Or am I going to need to define robbery?
It's established by a conviction, so you would need to define robbery.
Okay, that may have been the only reason we were defining robbery, so we would not need to if there's a conviction in for him. So we can take that out of our jury charge. I'm glad you pointed that out, Mr. Abadi. That'll make it somewhat easier.
They spent a decent amount of time talking about that robbery clause the other day, so you would think that someone would realize, hey, we're not actually, we don't need to establish that.
Oh. All right, I'll have to look in a second.
Aaron, I still feel like there's time for more screw-ups. Natasha Walker says, I can't believe it's coming to an end. I'll miss being slime with you. Like, yeah, I mean, we're going to look at the other trials.
Okay. It doesn't look like there are any other overt acts, because I just did a global search in the indictment for the term convicted felon, and that looks like those were all of them that didn't otherwise have some definition anyway.
Unless it was written wrong in the indictment, which is a strong possibility here. But also, I want to look for other cases that these attorneys end up trying, like anything that's also streamed. Like, imagine watching a different Doug case or a different Max Shark case. So, I think that'll be a good time. Always really impressed that, you know, Doug came from the civil litigation world. And he's coming over here laying down the hammer in the criminal defense world. Really awesome to see. Big thank you here, Natasha Walker. Forever Young says this is like checking the state's homework, and as usual, the dog ate it. And Natasha also gifted 5 memberships. Show love to Natasha in the chat. This is super nice. Oh, squeaky. I mean, I guess we can kind of hear. It's really Whitaker and Ms. Persifield making the changes in the live document, I think, based on what's written on paper. So I don't know if you guys want to listen to this. I know if I skip forward, we're going to miss the court talking to the parties. Oh my god, and then they go on a break. Hold on.
if they aren't saved in the document.
All right, so let's listen to this and see. They look like they pan to the seal. And this is why we started late. Yeah,
I'll
good
continue
cue,
to
right?
Go up to my chambers and see if some changes might be saved on my computer up there if they aren't saved in the document.
All right, so she's going up to chambers.
Yeah.
Oh my gosh. There we go. So, just like that, we'll be caught up. There we go. There we go. Kokomo's popped in. He's in court, and someone said the Matthews are in court. That's interesting. I mean, I feel like they're probably in that building, like most days, they're probably already into other trials, right? There's just a ton of cases that each of these attorneys seems to have backlogged because of this trial. So, really cool that if they're in court anyway and they decided to pop their heads in, show some support. That's pretty awesome. Yvette says, hello to all the judges across the world screaming at their TV because of this trial. And what time was the jury? They were told 11 a.m., right? Jury was told 11 a.m. So that's 8 minutes from now, if I'm remembering correctly. So let's see if they get the jury going on time, because remember last week a big priority for Whitaker was, look, they're going to come in late on Tuesday. We want to get the most out of the time. We want to make sure they can start deliberating if they want to Tuesday afternoon. She told them, I think, 11. Okay, so we've got a lot 11. We have one saying 11:30, but around this time, so. Oh boy. And is the seal, like, the camera zoomed out, right? The seal looks really little today. Oh man. Maurice said, give him the long view. Gina says, thanks for the 2. How long will the jury instructions take to read? You know, I don't really know, but when they were preparing the jury instructions, at least for the counts itself, right? I don't know if we saw all the clauses relating to anything that might need to be instructed about an individual overt act. I think it was like 30-something pages. That's not the longest. That is not, compared to how long this trial has taken and how big the indictment is, I don't think that that's necessarily that long. Now, what I'm not saying is that this is going to be easy, breezy, beautiful. Like, this is not going to be a speedy 5 minutes, we give you the instructions, and then it's done. It's probably going to be long-winded, and depending on how Paige delivers it, you know, she might do her switch of tone, speed read it, who knows. I don't think it's going to be less than 2 hours to get through it all, reading it. But do I think it'll take 4 or 5 hours? I sure hope not, and I don't think so. So I do think the jury will get to start deliberating middle afternoon, late afternoon today. But I don't have an exact, because I haven't seen the full document or the length of the final document. So, but I would love if it's on the shorter side. I would love, love, love if it's on the shorter side. But I'd expect, give yourself about 2 hours time. If it takes longer than 2 hours, then you might as well wait, come back and watch it on 2 times speed. Oh boy. And then Ezekiel says, this will all be moot once the jury returns in less than half an hour with a jury nullification, not guilty. Right, and the jury doesn't, they're not supposed to be told about jury nullification and that they can decide that, you know, besides what they're asked to do in deliberations, do you think the state has proven X, Y, Z beyond a reasonable doubt? Have these elements all been met? Yes, no, not guilty, guilty. Besides that, juries can say, you know, we're just going to find not guilty. Even if they did present enough evidence, screw them. Like they can do that, but they're not supposed to be told they can do that. I think jury nullification, you can never really tell for sure, right? But I think most juries, I would expect that most juries return a verdict because they deliberated, not just because of jury nullification. But if there was a situation where I think it's more possible than usual that the jury might say, F these guys, This might be a good example. 167 days. So, you know, again, this is like unprecedented. And yesterday, I think there was some conversation, some questions, can that be considered misconduct? Now, jury nullification is not juror misconduct. Now, if the state feels like they want to fight, they suspect that jury nullification was at play, they might go looking for any reason to find something about one of the jurors to say they acted inappropriately or they shouldn't have been impaneled and it was misjuring voir dire. But those are separate arguments. Those are separate mechanisms than just complaining about jury nullification. The state can't just say, hey, the jury didn't have the right to find the defendant not guilty. The state can't say that. So, and if you guys want an official, what is jury nullification? I mean, and I think I gave like the common sense explanation, but let's see. Here you go. Jury nullification refers to a jury's knowing and deliberate rejection of the evidence or refusal to apply the law, either because the jury wants to send a message about some social issue that is larger than the case itself, or because the result dictated by law is contrary to the jury's sense of justice, morality, or fairness. Essentially, with jury nullification, the jury returns a not guilty verdict even if jurors believe beyond a reasonable doubt that the defendant broke the law. This can occur because a not guilty verdict cannot be overturned, and jurors are protected regardless of their verdicts. And something you guys heard me talk about, a really great stream that Stephen Gosney, he's gone into private practice, I think in the civil realm, but he's successfully won appeals for death penalty cases, just a bucket full of knowledge. And he made a really good point. He underscored something in the stream 2 days ago on Excited Utterance channel, and he highlighted Florida. So that's cool. He practices here in Florida. I'm in Florida, so I thought this is extra cool. That we hear a lot of appellate issues on the grounds that, a defendant feels like the prosecution was shady or tried to discriminate in the way that they seated a jury panel. And yes, we tried to raise the issue to the judge at the time, but the judge is like, oh no, they gave some latent reason. It wasn't just a reason relating to a protected class, blah, 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 blah. And we usually look at that, we hear about that in the context of the defendant raising the issue on appeal. But what he talked about, and he used Florida as a specific example, Florida looks more, the statute and case law looks to protect the jurors themselves, reminding anyone questioning it that jurors have the right to sit on a jury. And that seems like common sense, but to hear it said out loud really was good food for thought. The juror has the right to be seated on a jury. That's why you have to give a reasonable basis to strike a juror. And when you talk about an issue like jury nullification, and you see something here, that jury nullification can occur because a not guilty verdict cannot be overturned, and jurors are protected regardless of their verdicts. So, right, we often think that the defendant has all these rights, but jurors also have rights. And these rights that jurors have, in instances where jury nullification comes into play, coincidentally tend to benefit the defendant, right? Jury nullification is something that will benefit the defendant because it's regardless of the evidence that the state has presented, even if it met the reasonable doubt standard. There's another reason we're going to find this defendant not guilty. We want to send a message, right? So this is something that always leans in the favor of the defendant. And because the jury is protected, there isn't really a solid mechanism that the state can appeal. Oh, they use jury nullification and we know it. They might weasel around and try to find another argument to make to attack this indirectly. But it's an important thing. I don't think it's all that common that this is in play, but really, really important concept. So, and I want to pull up, I mentioned it yesterday. Hopefully it's right here in my YouTube history. This stream, and again, the title of it is talking about the Koberger case, but they really don't get into the facts of the case itself. It's like a deep case law dive. Really, really, really interesting stream. Okay, yes, here it is. So here's Ghazni on Excited Utterance. Dolly Talk also made a guest appearance there. Yeah, we'll get this back over in case they pop back in. So, but yeah, again, do you guys get what I'm saying though? Like, this case in general, to me, seems like a bigger opportunity than normal for this jury nullification. And it makes me think of Hilton's opening, where she's so focused on redeeming herself when she felt personally slighted or slighted as a team, that they're just targeting Black community members. And again, that's not what Doug's point was. Doug was talking specifically about the lyrics, right? We only go after certain groups of people, a certain genre, targeting them through their lyrics, right? That's very different than just saying we're targeting a specific demographic. But Hilton took that and ran with that and came out loud, voluminous, defensive with her opening statement. And, you know, if the jury sits there and says, well, even though she said all that, we actually think she is targeting members of our community unfairly, or maybe the investigators are, maybe the APD are, maybe not Hilton herself, but we don't like the way the investigators do this. And we want to send this message that we're not allowing this. We're not going to let you get these convictions because we don't like the way that you have your APD, you have Miss V, Miss Marissa Viverito, sitting out here in the bushes with binoculars, watching people in what she calls their natural habitat. And we don't like that. We don't like that. And then when they finally come up, they're in there and watches go missing. Well, screw all that. Screw all that. That would be an example of jury nullification. If the jury sits there and says, so what if Shannon was in possession of these guns? So what if we think the medical examiner's wrong? We don't care that Shart said 34 seconds went by between Shannon Stillwell pulling away and then us seeing Shamel Drinks hit those brake lights in his car. 34 seconds passed. And his body was still functioning when the ME said it would be instant immobilization, which Hilton also misrepresented in her closing argument. They could say, you know what? We don't agree with Shart's argument there. We actually agree with Hilton's, that he must have been shot. But screw all of this. Just big F you to the state. That would be jury nullification. And it seems like the state might be afraid of that. Seems like they might be afraid of that. And I don't think that Hilton's response was just in isolation a response to Doug's closing. I think this has been something that's kind of like a guilty conscious voice in her head. Like, hey, people think that you're just doing this because you're targeting people. And I think it's eating away at her. I feel like she was yearning for this chance to get up there and speak her piece and tell the world that that's not what she's doing. That's not what the state's doing. Because I will never forget that non-jury day when she was arguing she wanted to show the jury that apprehension video of Christian Eppinger. And I'm thinking, you know, maybe they just want to show it because it's kind of prejudicial, right? It makes people look guilty when they're surrounded by a SWAT team, right? That's a scary thing to see. So it's a prejudicial image, and she just wants the jury to see something prejudicial to the rest of the defendants that are said to be associates of Christian Eppinger. But what was her reason? What was her reason for wanting that video? I was shocked when she said this reason. I thought maybe she wanted to show consciousness of guilt because he was saying, just let me die. And she was going to say, well, that's something that somebody that's guilty and doesn't want to do their time in prison might say, right? No, that wasn't her reason. Her reason was because she wanted to show how police officers don't always treat Black members of the community poorly. That was her reason. She wanted to bring that video in as a statement about community policing methods. That was the most insane thing I've ever heard come out of someone's mouth in this trial. Her reason for wanting this apprehension video in. And then she started her opening statements with both shields up, holding two shields like, we are not out here. And the state, remember, that's state is APD and it's the prosecution's office. Both same arms of the same team, or different arms of the same team. She's had that weight on her shoulders for so long. I think she's had that on her shoulders for so long. And again, a big issue. The jury could say, we don't like that. We want to send a message. We want to send a message. So there's my rant. Like, you know, I say I get done with these streams, I marinate on some things. And man, that Christian Eppinger apprehension video, that evidentiary argument just sat there like rerunning in my head last night. Like, this Lady Hilton. This Lady Hilton. So. And let's see here. What are you guys thinking? Let's see. Jilly D says, after being yelled at for 2 hours, I would have to use my voice with a loud not guilty. And, you know, that's the thing, right? I feel like this chat here, the consensus was, oh my gosh, why is she yelling? But then we see Love sitting there like, this is the best thing I've ever heard in my life. And there could be a Love on that jury. There could be a Love. There could be a Love. Yes, Michael, this Vivarito hiding in the bushes is a quote from her Daubert hearing transcript. That's not an exaggeration. She said she'd be in the bushes on Cleveland Avenue watching the citizens in their natural habitat. So, oh man. Oh my goodness. Like, and it's crazy. Like, that's why let me underscore that, yes, that's a real thing. This bush is not an exaggeration. And it's crazy, right? Isn't that crazy? I see Apunan was saying I meant Woody. Do you mean W-O-O-T-I-E? Wooty? Wootai? Yeah, this is great, Sean. You're right. Are there 12 loves? No. I would not imagine. I surely hope not. Oh my gosh. What a horrible job on voir dire if 12 loves made it onto the jury. Shame on those very skilled and talented and hardworking defense counsel if this was the jury pool that ended up being selected. But remember, right? If there's one, that's a holdout. A hung jury isn't exactly a win. Hung jury isn't exactly a win because it can be retried. And after Hilton's closing argument, do you think the state would look at this if the jury was hung and said, you know what, we just don't know. It was really a thin line. We're not going to re-prosecute this. We're not going to run this through again. There's no way they're not going to retry this. So a hung jury, in my opinion, in this case, is absolutely not a win. It's, of course, better than a straight conviction. But, you know, hung jury is not the end of the road. So, and yep, Jorge, I think this is a huge risk. My timeline was filled yesterday with everybody talking about how much of a dumpster fire the closing was. Fair enough for the state, for Hilton. But at the same time, I think it was way more cogent than anything else we've seen from the state, right? And again, that contrast is why I'm able to say that. That's not me saying I loved her closing statement. I'm just saying there was a contrast. There was somewhat of a storyline. Doesn't mean she wasn't misrepresenting things or making big reaches or saying things that didn't resonate with me. But I think compared to the 165 days that preceded yesterday, by contrast, it was much more coherent and cogent. And if they get to start over with this trial and maybe have Love take a back seat, and they get to follow that storyline more concisely, and maybe it only takes them 30 days, because they're only going to deal with these two co-defendants. That could be bad. I think the defendants and the defense attorneys would look at that as being a disadvantage, right? I think a redo would be more advantageous for the state than it would be for the defendants, right? A lot of factors at play, though, so that's not a hardline opinion. But, you know. Is that Shart walking by the... Just see a bolt. Shart's taking a moment to say hey to the camera here. Yeah, Fletch, I do think this is important, and little things matter. Even today you hear Whitaker say, Doug, I want you to know I appreciate your candor to the court. Fletch says the defense emphasizing both of them, Shart and Weinstein, how they valued the jury's time probably really hit home with them. And the prosecution really didn't do the same thing. The prosecution was like, you have a duty to go work more, go deliberate. You can't just go in there and decide, this is BS, we're coming out, right? A weird instruction there coming from the prosecutor. And let's see. Where was that slide? There was a really annoying slide yesterday. This. So you have Doug Weinstein thanking the jury for their time. You have Max Shart thanking the jury for their time. Then you have this slide from, I think Hilton put it up. Yeah, Hilton put this up. After she got done with her spiel about countering Doug's point about the lyrics, she makes a case. Now here's the distractions. Here's the bike and the sand basket story. Here are the 6 things that are the sand basket for the defense. And one of the bullets, she says, is length of time. They're trying to distract you by making you think about the length of time this trial has taken. If you have a juror send an email that they clearly rewrote. Now, if I don't care about something all that much, I'm just going to quickly write a reply and send it off. If I'm really feeling in my feelings, I'm going to be like, let me hit the brakes. Let me reread this. Because maybe I'm a little heated because I care about this issue a lot and maybe I just need a breath. We know this juror redid his email. We heard that from the judge. That sounds like me to someone who takes this length of time being wasted very seriously. The message in the email suggests that. And then Hilton gets up there and says, it's just a distraction. Who cares about the length of time this has taken? What a dumb and tone-deaf thing to put in this slide. The defense case. Stolen jewelry, no reports, length of time, knowledge of co-conspirators, witness credibility, and music art. Are any of these things not relevant or distractions? Stolen jewelry, I would argue, goes to witness credibility. So, and knowledge of co-conspirators, that's an element. That's a necessary element. Was this knowingly and willingly? Were they participating with the others? It's just a distraction. Who cares about an element? This is one of the most infuriating things I've ever seen in my life, is this slide. No reports is just a distraction. What was her counter during her closing? Oh, but then at the same time, oh, we're back. We're back. Someone's opening their soda. You guys got saved from a long-winded cat rant. Let's get back over here. And I'll also link to that slide if you want to go look at it and vent in your own world. Like I may have spent too much time doing yesterday. Did they mute us as soon as we flip back?
Your Honor, we've located some authority on main cases, United States versus Elliott 571, F2nd 880. It's a former Fifth Circuit case. Elliott dealt specifically with the question where the defendant argued that acquittal on a RICO substantive did require the acquittal on a RICO conspiracy, and the court said no, it did not.
Yeah, that's not.
It's an often, it draws the distinction, but that being said, we are looking at the changes that were just forwarded to us, and think that there, for the vast majority of these, there may be a pretty simple, direct workaround that addresses the issues we've been talking about.
Okay. Well, I'm not sure we need to decide it before the jury charges anyway, so. All right. Anything else then? Otherwise, I'm going to have the jury out and go ahead and charge them. All right, let's get the jury out.
Jury's finally coming out. It sounds like the volume's okay, but Floyd, whatever, didn't have his mic on there. If it's an issue, we can go back over to 11 Alive. Oh my god, the scowl on Love. Hold on. Look at this. Look at the screen. Shout out to JH. Thank you so much for the 3. Thanks for showing the love. William Fagan says, did they lay hands on Hilton? She seems to have removed Love's spirit from her body. They did a little Reiki session. Yesterday she was doing Love, doing Fani quite badly. I'd rather listen to Hilton do that than Love. I don't know. Pick your poison, chat. Would you rather listen to Hilton or Love for 2 hours? Something with a no-win solution there. Updating us again. Aw, Cash Money Cass, it's our 4-month anniversary. Gosh, this trial is so long. So awesome, so glad to have met you. You make me laugh so much, so you were super appreciated. Okay, we do have a neither. That's not fair. There was no, that wasn't an option. Everyone's saying Hilton, Hilton. Hilton, Hilton. Hilton, Hilton. None and pass on both. Those aren't options, guys. You gotta choose. Oh, you know, actually, I like this point. Corky says, at least that's just Love's personality. But Hilton was aggravating, right? Although Hilton, I mean, Love has done that soft baby voice with 2 of the witnesses. And how are you doing today? And the whole chat's like, what? Who is this Love? Who is this new person, this new voice? No, this isn't verdict. This is the reading of jury instructions. So this is going to be really for us the first time to see and hear the final version, even though we've seen some of the arguments about how we should word the clauses and blah, 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 blah. But it's kind of a big deal because they're changing the way. We already know that they're changing some of the counts, the substantive acts that are going back to the jury because of that 16-11-133 count, which was just mangled garbage in the indictment, missing a whole element. But the judge is allowing a lesser included. And now they're considering doing the same for the overt acts that cite the same statute for the related acts. So we'll see final decisions on some of these back and forths. And just listening, I'm curious to see what still includes the names of people that pled out. I think it's advantageous to hear more names than the 2 on trial because you give the jury an out to say someone else did it besides these 2. All right, unmute us. Maurice. Maurice. Okay, the court is muted, guys. We just gotta read lips today. Everybody channel Maurice. All right, so I mean, it's probably just small talk, like, you know, you've sat here for the days, you've heard the evidence, the case is like concluded.
Violation of the Georgia
There we
Controlled
go.
Substances Act, 61, possession of a firearm during the commission of a felony, and 63, possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm. Mr. Stillwell has been indicted for counts 1, conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act. 2 and 49 are counts of murder. 50, participation in criminal street gang activity pursuant to subsection 1 of that statute. 51, participation in criminal street gang activity pursuant to subsection B of that statute. 2 counts of possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm in counts. Those are counts 52 and 64. And then count 54, which is possession of a firearm during the commission of a felony. You will have a copy of the indictment with the relevant charges with you during your deliberations. Each defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The instructions that I give you will apply to each defendant individually. So when I say the defendant or a defendant, The instruction applies equally and separately to each defendant. Further, your determination of the issues set forth in the verdict forms must be made as to each count and as to each defendant individually. A defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It's a reasonable doubt is a doubt of a fair-minded and impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt. It's a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If after considering the evidence, you believe beyond a reasonable doubt that a defendant is guilty of an offense alleged in the indictment, you would be authorized to convict the defendant of that offense. If the state fails to prove the defendant's guilt of an offense beyond a reasonable doubt, it would be your duty to acquit the defendant of that offense. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged or that merely raise a speculation or conjecture of the defendant's guilt are not sufficient to authorize a conviction of the defendant. Your oath requires that you will decide this case based upon the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes the testimony of the witnesses, the exhibits admitted during the trial, and any stipulations of the attorneys, which are facts to which the attorneys have agreed. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. The parties have entered into stipulations about certain facts, and these 4 stipulations are marked as joint exhibits. Where parties stipulate facts, that is in the nature of evidence, you must take that fact or those facts as a given without the necessity of any further proof. You make all decisions based on the evidence in this case. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and to reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. There's no legal difference in the weight that you may give to either direct or circumstantial evidence. Direct evidence is that which can be seen or heard or otherwise directly sensed. It may be brought into court in the form of exhibits or the testimony of a person who asserts that he or she has actual knowledge of a fact by personally observing or otherwise witnessing that fact. It is evidence that points immediately to the issue in question. When direct evidence points by inference to an obvious, likely, or reasonable conclusion, even though that conclusion is not directly observed or otherwise sensed, that's said to be circumstantial evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that tends to prove or disprove another fact by inference, that is, with consistency with such a fact or elimination of other facts, or that only tends to establish a conclusion in question by its consistency with such conclusion or its elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence alone, the proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or a greater degree of certainty on the part of you, the jury, to return a verdict based on circumstantial evidence than upon direct evidence. There's no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for you, the jury, to decide. And whether it's dependent upon direct or circumstantial evidence or both, the true test is whether there's sufficient evidence, whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. You, the jury, must determine the credibility of the witnesses. In deciding credibility, you may consider all of the facts and the circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or their lack of interest in the case and the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are witnesses who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it's properly entitled to receive. In determining the credibility of a witness, you may consider, where applicable, evidence offered to attack or challenge the witness's credibility, and this may include evidence of a character for untruthfulness, bias toward a party, or felony criminal convictions. In determining the credibility of any witness whose credibility has been attacked or challenged, as I've described above, in any testimony given by him or her in court, you may consider, where it's applicable, evidence offered to support the credibility or believability of such a witness. The credibility of a witness may also be attacked by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony that the same witness gave before the trial started. It's for you to decide whether there's a reasonable explanation for any inconsistency in a witness's pretrial statements or testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. In assessing the credibility of a witness, you may consider any possible motive in testifying if that is shown. In that regard, you are authorized to consider any possible pending prosecutions, negotiated pleas, grants of immunity or leniency, or similar matters. You alone shall decide the believability of all of the witnesses. The testimony of a single witness, if believed, is generally sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. An exception to this rule is made where the witness is an accomplice. The testimony of an accomplice on its own is not sufficient to warrant a conviction. An accomplice's testimony must be supported by other evidence of some type, and that evidence must be such as would lead to the inference of the guilt of the accused, independent of the testimony of the accomplice. It's not required that supporting evidence be sufficient to warrant a conviction, or that the testimony of the accomplice be supported in every material particular. The supporting evidence must be more than that a crime was actually committed by someone. It must be sufficient to connect the accused with the criminal act, and must be more than sufficient to merely cast upon the accused a grave suspicion of guilt. Slight evidence from another source that connects the accused with the commission of the alleged crime and tends to show participation in it may be sufficient supporting evidence of the testimony of an accomplice. In order to convict, that evidence, when considered with all of the other evidence in the case, must be sufficient to satisfy you beyond a reasonable doubt that the accused is guilty. The testimony of one accomplice may be supported by the testimony of another accomplice. Whether or not the testimony of one accomplice does in fact support the testimony of another accomplice is a matter for you to decide. The sufficiency of supporting evidence of an accomplice is a matter solely for you to determine. Whether or not any witness in this case was an accomplice is also a question for you to determine from the evidence in this case. Any out-of-court statements made by one of the defendants on trial in this case after the alleged criminal act has ended may be considered only against the person who made the statement and only if you find such statement was freely and voluntarily made. If you find that an out-of-court statement was made to the police freely and voluntarily by a defendant on trial in this case, then you are to consider the statement only against the particular defendant who made it.
Taking that drink.
A defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. However, a defendant does not have to present any evidence nor testify. If a defendant chooses not to testify, you may not consider that in any way in making your decision. Sometimes evidence is admitted for a limited purpose or against some parties and not others, or for some counts and not others. I have previously instructed you as to how to consider particular evidence that was limited over the course of this trial. Such evidence may be considered by you only for the sole issue or purpose or against only the party or only for the counts for which that evidence was limited, and not for any other purpose or against any other defendant or for any other counts. You have received evidence of certain prior convictions of these defendants as well as certain other witnesses in this case. You may consider the conviction of Mr. Kendrick only against Mr. Kendrick and only as to count 1 and as to the required element of being a convicted felon in count 63. You may consider the convictions of Mr. Stillwell only against Mr. Stillwell and only as to count 1 and as to the required element of being a convicted felon in counts 52 and 64. You may consider the convictions of any witnesses only insofar as they may relate to attacking the credibility of that witness and not for any other purpose. Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witness or witnesses offered for this purpose. You should consider all of the factors previously charged to you regarding credibility of witnesses. In addition, some but not all of the factors you may consider in assessing the reliability of any identification are the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident, the witness's degree of attention toward the alleged perpetrator at the time of the alleged incident, the possibility of mistaken identity, whether the witness's identification may have been influenced by factors other than the view that the witness claimed to have had, whether the witness on any prior occasion did not identify that person as the alleged perpetrator, and the length of time between the crime and the out-of-court or any out-of-court identification. It's for you to say whether under the evidence in this case, the testimony of the witnesses and the facts and circumstances of the case sufficiently identify someone beyond a reasonable doubt as the alleged perpetrator or a party to an act. It is not necessary that the defendant show that another person committed the alleged act. The burden of proof never shifts to the defense. Defendants are charged with crimes against the laws of this state. A crime occurs when a law is violated by a defendant's intentional action. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided that you, the jury, believe it existed from the facts proven before you. It may be inferred from the proven circumstances or by acts and conduct, or it may, in your discretion, be inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a criminal statute, but it simply means the intention to commit the act that is prohibited by a statute. A defendant will not be presumed to have acted with criminal intent, but you may find such an intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. Whether or not you make any inference or inferences such as that is a matter solely within your discretion as the jury. Every party to a crime may be charged with and convicted of commission of the crime. A person is a party to a crime only if that person directly commits the crime, intentionally helps in the commission of the crime, or intentionally advises, encourages, hires, counsels, or procures another to commit the crime. A party to a crime who did not directly commit the crime may be prosecuted for commission of the crime upon proof that the crime was committed and that the person was a party to it, even though the person alleged to have directly committed the crime has not been prosecuted or convicted, has been convicted of a different crime or degree of crime, is not amenable to justice, or has been acquitted. Knowledge on the part of the defendant that the crime of murder, that's counts 2 and 49, possession of marijuana with intent to distribute, count 58, or possession of a firearm, counts 52, 54, 61, 63, and 64, was being committed, and that the defendant knowingly and intentionally participated in or helped in the commission of such crime must be proved by the state beyond a reasonable doubt in order for you to convict on those counts. If you find from the evidence in this case that the defendant had no knowledge that the crime of murder, possession of marijuana with intent to distribute, or possession of a firearm in the counts that I just referenced was being committed, or that the defendant did not knowingly and intentionally commit, participate in, or help in the commission of the alleged offense, then it would be your duty to acquit the defendant of that count. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crime of murder, possession of marijuana with intent to distribute, or possession of a firearm in the counts I just mentioned was being committed, and that the defendant knowingly and intentionally participated or helped in the commission of it, then you would be authorized to convict the defendant of that count. You are not authorized to find a person who is merely present at the scene of the commission of a crime at the time it was committed guilty of consent in and concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in its actual perpetration of the crime, or participated in the criminal endeavor. You are not authorized to find a person who is merely associated with other persons involved in the commission of a crime guilty of consent in or concurrence in the commission of a crime, unless the evidence shows beyond a reasonable doubt that the person helped in the actual perpetration of the crime or participated in the criminal endeavor. Next, I'm going to define for you the elements of the crimes that are alleged as counts against either defendant. Then I will define the meaning of any crimes that are alleged as an overt act, but that I have not yet defined. When a count of an indictment charges that a defendant committed a crime in more than one way, the state does not need to prove that the defendant committed the crime in every one of the ways alleged. The state may prove that the defendant committed the crime in any one of the ways charged. If the evidence shows that the crime was committed by the defendant in any one of the ways charged, you would be authorized to convict him of that count. And RICO is one of the counts that is charged as having been committed in more than one way. In order to convict, the state must prove that the crime was committed by the defendant in at least one of the ways charged. For conspiracy to violate subsection A of the Racketeer, Influence, and Corrupt Organizations Act, which I'm going to refer to from now on as the RICO Act, the state must prove that the defendant knowingly and willfully conspired with one or more others, co-conspirators, to acquire or keep money or other personal property through a pattern of racketeering activity, and that any of the co-conspirators committed an overt act after May 10th of 2017 to further a criminal objective of the conspiracy. For a conspiracy to violate subsection B of the RICO Act, the state must prove that defendant, while associated with an enterprise, knowingly and willfully conspired with one or more others to participate in the enterprise through a pattern of racketeering activity, and that any of the conspirators committed an overt act after May 10th, 2017 to further a criminal objective of the conspiracy. Conspiracy means an agreement between at least two people to commit an unlawful act. The agreement may be express, that is, stated or written, or it may be tacit, that is, a mutual but unspoken understanding to accomplish or to pursue a common criminal objective. The existence of a conspiracy may be inferred from the nature of any acts done, the relationships, interests, or conduct of the alleged conspirators before and after any alleged offense, and other circumstances which may disclose a common criminal design. However, mere association with an enterprise is insufficient by itself to establish a conspiracy to violate the RICO Act. The state does not need to prove that each conspirator agreed with every other conspirator, knew all of his fellow conspirators, was aware of all of the details of the conspiracy, or contemplated participating in the same interrelated crimes as every other conspirator. Whether a conspiracy existed is a matter for you to determine. Overt act means an outward act made in furtherance of a conspiracy. The overt act may, but does not have to be, a crime in and of itself. Some of the overt acts alleged in this indictment, if proven, would be crimes. You can tell which those are when you have the indictment back with you, because they will list a cite to a criminal code section. Later in these instructions, I will define for you any alleged crimes that are alleged in the overt acts that I have not already defined when I'm defining the substantive counts. Enterprise means a group of individuals who are associated in fact, whether or not all of the members know each other. To be an enterprise under the RICO Act, the group must have a common purpose and ongoing nature sufficient to pursue its purpose or purposes, and at least a loose or informal relationship amongst those involved. The group does not need any form or structure beyond what is necessary to conduct a pattern of racketeering activity. The group may be associated together for both legal and illegal purposes. In determining whether an enterprise existed, you may consider any evidence of a pattern of racketeering activity. When people conspire together in an unlawful enterprise, any act done by any of the conspirators to further the unlawful enterprise is considered to be an act of all of the conspirators. However, each conspirator is responsible for the acts of other conspirators only to the extent that those acts are naturally or necessarily done to further the unlawful enterprise. If you find that the defendant did not knowingly and willfully join a conspiracy as described above, then you cannot contribute the statements or acts of another person to the defendant. Racketeering activity means committing or attempting to commit any of these crimes: murder, attempted murder, aggravated assault, aggravated battery, theft by receiving stolen property, armed robbery, terroristic threats, use of an item with an altered identification mark, possession of a firearm during the commission of a felony, possession of a machine gun, possession of a firearm by a convicted felon, possession of a firearm by a first offender probationer, possession of a weapon by an inmate, possession of a cell phone by an inmate, possession of codeine with intent to distribute, possession of hydrocodone with intent to distribute, possession of marijuana with intent to distribute, possession of MDMA with intent to distribute, possession of methamphetamine with intent to distribute, possession of cocaine, or possession of oxycodone. I will define these crimes for you shortly. Racketeering activity also means any act or threat that involves murder, robbery, theft by receiving stolen property, or dealing in narcotic or dangerous drugs. A pattern of racketeering activity means engaging in at least 2 acts of racketeering activity within 4 years of each other in furtherance of one or more interrelated incidents, schemes, or transactions. Interrelated here means acts that have the same or similar intents, results, accomplices, victims, or methods of commission, or that are otherwise interrelated by distinguishing characteristics and that are not isolated incidents. The criminal objectives of the conspiracy alleged here are preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity, including murder, assault, and threats of violence, obtaining money, weapons, or other property through acts of racketeering activity, including robbery, theft, and the unlawful sale and distribution of drugs, and obstructing law enforcement investigations and court proceedings through witness intimidation and attacks upon law enforcement officers. A person commits the offense of violation of the Georgia Street Gang Terrorism Prevention Act, which I'm going to refer to from now on as the Gang Act, when that person, while associated with a criminal street gang, commits a crime that constitutes criminal gang activity. To prove a violation of subsection A of the Gang Act, as alleged in counts 50 and 57, the state must show the existence of a criminal street gang, that the defendant is associated with that criminal street gang, that the defendant committed or participated in criminal gang activity, and a nexus, that is a connection between the crime committed and the gang, i.e. that the crime was committed to further the interests of the gang. To prove a violation of subsection B of the Gang Act, as alleged in count 51, the state must show the existence of a criminal street gang, that the defendant is associated with that criminal street gang, that the defendant committed or participated in criminal gang activity in order to maintain or increase his status or position in the gang, and again, a nexus or a connection between the crime charge and the gang. That is, that the crime was committed to further the interests of the gang. Criminal street gang means any group of 3 or more persons associated together which engages in criminal gang activity. The existence of a criminal street gang may be established by evidence of a common name or common identifying signs, symbols, tattoos, graffiti, or attire, or other distinguishing characteristics, including but not limited to common activities, customs, or behaviors. Criminal gang activity means the commission, attempted commission, conspiracy to commit any criminal offense that involves violence, possession of marijuana with intent to distribute, possession of a weapon, or use of a weapon. For purposes of count 50, 51, and 57, which are the gang counts, murder, possession of marijuana with intent to distribute, and possession of a firearm during the commission of a felony constitute criminal gang activity. For malice murder, the state must prove that a defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice where there does not appear to be significant provocation and all of the circumstances of the killing show an abandoned and malignant heart. The state does not have to show premeditation to prove murder. If a killing is done with malice, it is murder, regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proved by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or lack of it. The state may, but does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. For possession of a firearm during the commission of a felony, the state must prove that a defendant had a firearm on his person or within arm's reach of his person while committing a felony, which is one of the following: a crime against or involving another person, or a crime involving possession of marijuana with intent to distribute. Murder and possession of marijuana with intent to distribute are felonies, and for purposes of this offense, a firearm includes any handgun. The indictment charges each defendant with possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm. I am not going to charge you on that crime because the state concedes that the description of the crime in the relevant counts of the indictment left out an element of either the defendant having previously been convicted of a felony, or of the defendant having previously been convicted of a felony involving the use or of possession of a firearm. That should be or. So you will be considering only the lesser included offense of possession of a firearm by a convicted felon when you get to those counts. And for possession of a firearm by a convicted felon, the state must prove that the defendant possessed a firearm after having been convicted of a felony. Possession of a firearm during the commission of a felony and possession of a firearm by a convicted felon are both felonies. And again, for purposes of this offense as well, a firearm includes any handgun. For possession with intent to distribute marijuana, the state must prove that the defendant possessed any amount of marijuana with intent to distribute. Intent to distribute means intent to unlawfully deliver or sell. Marijuana means all parts of the plant of the genus cannabis, whether growing or not, the seeds, the resin extracted from any part of the plant, and every compound, manufacture, salt, derivative, mixture, or preparation of such plant, its seeds, or its resin. Marijuana does not include the completely defoliated mature stalks of such plant, fiber produced from such stalks, oil or cake, or the completely sterilized samples of seeds of the plant which are incapable of germination. And it does not include hemp or hemp products, and it does not include samples of tetrahydrocannabinols, or THC. The state must prove that the defendant possessed the marijuana and or the firearm at issue in this case. Possession may be either actual or constructive. It also may be either sole or joint. Actual possession means that at the time of the alleged offense, the defendant knowingly had direct physical control over the marijuana or over the firearm, depending upon which count you're considering. Constructive possession means that at the time of the alleged offense, the defendant did not have direct physical control over the marijuana or the firearm, but did knowingly have both the ability and the intention to exercise control over the marijuana or the firearm. Sole possession means that only the defendant had possession of the marijuana or the firearm. Joint possession means that the defendant shared possession of the marijuana or the firearm with at least one other person. If you find that someone other than the defendant had an equal opportunity to possess the marijuana or the firearm, you would be authorized to convict the defendant only if the state proves that the defendant knowingly possessed the marijuana or the firearm. And I'm now going to define for you any alleged crimes that are alleged in the overt acts that I have not already defined in the substantive counts. So the following definitions apply only to certain acts that are alleged in count 1 of the indictment as overt acts. Aggravated assault with a deadly weapon. For aggravated assault, the state must prove that the alleged perpetrator assaulted another person with a deadly weapon. Assault means to commit or to attempt to commit a violent injury on the person of another. And to prove assault, the state doesn't have to prove the other person was actually injured. However, the state must prove that the alleged perpetrator attempted to cause a violent injury to the person. An offensive weapon is any object that is likely to cause or actually does cause death or serious bodily injury if used against someone. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. Aggravated battery. For this crime, the state must prove that for aggravated battery, the state must prove that the alleged perpetrator maliciously caused bodily harm to another person by seriously disfiguring a part of the body. In deciding whether or not an alleged perpetrator acted maliciously, understand that malice is not ill will or hatred. Malice in this context means an intent to cause the resulting bodily harm without justification or excuse. Malice also means willfully doing an act while aware of a strong likelihood that the particular bodily harm may result. For armed robbery, the state must prove that the alleged perpetrator took another person's property from the immediate presence of the other person by using an offensive weapon and with the intent to commit theft. An offensive weapon is an object that's either likely to cause or actually does cause death or serious bodily injury if it's used against someone. Conspiracy to commit murder. A person commits conspiracy to commit murder when that person conspires with one or more others to commit the crime of murder. Murder has been previously defined. Criminal attempt. A person commits criminal attempt to commit a crime when, with the intent to commit that crime, the person performs any act that constitutes a substantial step towards the commission of the crime. Criminal gang activity has been previously defined. Criminal use, a person of an article with an altered identification mark. A person commits the offense of criminal use of an article with an altered identification mark when he possesses a firearm from which he knows that the manufacturer's serial number or any other distinguishing number or identification mark has been removed for the purpose of concealing or destroying the identity of that article. Possession of a firearm by a convicted felon has been previously defined, but in addition, with regard to that offense, possession of MDMA with intent to distribute, possession of cocaine, and robbery are felonies. Possession of a firearm by a first offender probationer. For possession of a firearm by a first offender probationer, the state must prove that the alleged perpetrator possessed a firearm while on probation for a felony as a first offender. Robbery and criminal damage to property are felonies. Possession of a firearm during the commission of a felony has been previously defined, but in addition, for these overt acts, possession of codeine with intent to distribute and possession of cocaine are felonies. Possession of a machine gun. The state must prove that the alleged perpetrator possessed a machine gun during the commission of any of the following offenses: participation in criminal street gang activity, possession of marijuana with intent to distribute, possession of codeine with intent to distribute, and possession of cocaine. A machine gun means any weapon which shoots or is designed to shoot automatically more than 6 shots without manual reloading by a single function of the trigger. Possession of controlled substances. For possession of cocaine or oxycodone, the state must prove that the alleged perpetrator possessed any amount of cocaine or oxycodone, both of which are controlled substances. Possession with intent to distribute. For possession with intent to distribute codeine, hydrocodone, marijuana, MDMA, or methamphetamine, the state must prove that the alleged perpetrator possessed any amount of marijuana or any amount of codeine, hydrocodone, MDMA, or methamphetamine, which are controlled substances, with intent to distribute. And intent to distribute means intent to unlawfully deliver or sell. Sale of marijuana. For sale of marijuana, the state must prove that the alleged perpetrator sold any amount of marijuana, and sell here means to transfer marijuana in exchange for money or anything else of value. Possession of a weapon by an inmate. For possession of a weapon by an inmate, the state must prove that the alleged perpetrator, while an inmate, possessed an unauthorized weapon. For possession of a telecommunication device by an inmate, the state must prove that the alleged perpetrator, while an inmate, possessed an unauthorized cell phone. Conspiracy to possess a telecommunication device by an inmate. A person commits conspiracy to possess an unauthorized telecommunication device by an inmate when that person conspires with one or more others to commit the crime of possession of a telecommunication device by an inmate. For terroristic threats, the state must prove that the alleged perpetrator threatened to commit a crime of violence and that the threat was made. Theft by receiving stolen property. A person commits theft by receiving stolen property when that person receives or keeps stolen property and the person knows or should have known was stolen unless the property was kept or received with the intent to restore it to the owner. Knowledge on the part of the alleged perpetrator that the property was stolen or evidence sufficient to show beyond a reasonable doubt that the alleged perpetrator had reason to know the property was stolen is an essential element of this offense. Knowledge that the property was stolen may be shown by circumstances that would excite suspicion in the mind of an ordinary person. The burden is on the state to prove beyond a reasonable doubt that the alleged perpetrator had knowledge or under all the circumstances should have had knowledge that the property in question was stolen and was in the alleged perpetrator's possession. All right, that's it for the overt act crimes. All right, the law provides that criminal action shall be indicted and tried in the county in which the crime was committed. In a prosecution in any case in which it can't be determined that what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt it might have been committed. We don't have that here, do we? So essentially just the state must prove that the criminal actions alleged as counts in this case, that they have to be tried and indicted and tried in the county in which the crime was committed. So venue, that is that the crime was committed in a particular county, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any other element of the offense. Venue may be proven by direct or circumstantial evidence or both. To prove venue for the RICO count, the crime is considered to have been committed in any county in which an incident of racketeering occurred or in which an interest or control of an enterprise or personal property was acquired or maintained. The defendants are each charged with certain offenses that are set forth in various counts of the indictment. Each count is a separate and distinct offense, and you must independently evaluate the evidence against each defendant and as to each offense. The fact that you reach a conclusion with respect to one offense or with respect to one defendant does not necessarily mean that the same conclusion will apply to any other charged offense or to another defendant. Each count of the indictment before you is separate and distinct. You must evaluate evidence as to one count independently from evidence of each other count. You must evaluate the evidence as to each defendant independently, and you must render a verdict as to each count and as to each defendant individually. If, after considering the testimony and the evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Fulton County, Georgia, committed an offense as alleged in the indictment, you would be authorized to find the defendant guilty of that offense. In that event, the form of your verdict for that offense would be to find the defendant guilty. If you do not believe the defendant is guilty of an offense as alleged in the indictment, or if you have any reasonable doubt as to the defendant's guilt of that offense, then it would be your duty to acquit the defendant of that offense. In that event, the form of your verdict for that offense would be to find the defendant not guilty. You are to make a separate determination of guilty or not guilty as to each offense and as to each defendant. Your verdict as to each count must be unanimous. That means that you must be unanimous in your determination that the state has proven every element of that count as defined and listed above beyond a reasonable doubt. And you'll have a copy of these instructions out with you so that you can see what each of the elements of each of the offenses is. Again, the elements are listed above where the crimes are defined, and you must be unanimous that each element has been proven. Let me explain what that means for a few of the elements for count 1 a bit more specifically. And that's the conspiracy to violate the RICO Act. You must be unanimous as to the pattern of racketeering activity that the defendant agreed would be committed. But because count 1 is charged as a conspiracy to violate the RICO Act, it's not required that the state prove that any conspirator actually committed an act of racketeering activity. And on the overt act element, you must be unanimous that a conspirator committed an overt act after May 10th, 2017 to further a criminal objective of the conspiracy. And you would note on your verdict form that and any other overt act committed in furtherance of the criminal conspiracy to which all 12 of you unanimously agree. By no ruling or comment that the court has made during the progress of this trial has the court intended to express any opinion upon the facts of this case, upon the credibility of witnesses, upon the evidence, or upon the guilt or innocence of either defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively, without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, or economic status for or against any party. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Talk with each other and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it's wrong. However, you should never give up an honest opinion simply to be congenial or to reach a verdict solely because of the opinion of other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. And these rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. Whatever your verdict is, it must be unanimous, that is, agreed to by all. The verdict must be in writing and signed by one of your members as the foreperson, dated and returned to be published in open court. During your deliberations, any communications from you to the court must be in writing, signed and dated by the foreperson, and given to a bailiff. And let me add that given that the evidence is closed, my ability to respond to questions may be limited. Evidence that was admitted by audio or video recording can only be played here in the courtroom, so any request to review or listen to that evidence again must be made in writing by you to the court, and then it'll be replayed in the courtroom. And that is the end of my instructions. I'm going to excuse you all to the jury room now to elect your foreperson. Don't begin deliberations until you have the indictment, the evidence, and the verdict forms and some copies of this charge out with you. And I'm going to ask jurors number 387, 409, 449, and 508 to hang back with me. And the rest of you can return to the jury room to elect your foreperson.
What were those alternates?
And the rest of you, 449, jurors number 387, 409, 449, and 508
56
to hang
is
back
in.
with me.
56 is in.
And the rest of you can return to the jury room to elect your foreperson.
All rise for the jury.
Was the one was it 3-8? Hold on, let me hear it one more time. Let me write them down. 300 something
You can return to
was
the
the
jury
other
room
one.
to elect your foreperson.
All rise for the jury.
Oh,
The rest of you, 449, jurors number 387, 409.
I think 387 was the one with the email from the text message from the employer.
449 and 508 to hang back with me. And the rest of you can return to the
409. Yeah, but I think 387 was the one with the employer issue. Where they're like, I heard the case is ending, I heard Doug's out of there. But 56 is in. I wish we could see Love's face. Oh my god. Everybody put a 56 in the chat. Hilarious, hilarious.
room to elect your foreperson.
All rise for the jury.
My bad. Let me get caught up. Wanted to make sure I heard those numbers correctly. Look at this look. Look at Doug. Hand on the shoulder. Max's tie.
All right, y'all are the alternates in the case. Considering the length of this trial, it was critical that we had alternate jurors in case we lost any jurors. And as I think y'all know, we in fact started with 2 more of you and lost 2 along the way. I don't know how long deliberations are going to take. And so it's possible that even now we may end up losing a juror or more. So y'all are still on jury duty. You're not going to be deliberating right now. But you continue to be under all of the instructions that have been applicable to you for the entirety of this trial. You cannot discuss this case with anyone. You cannot allow anybody to discuss the case with you. You cannot go now and look up any articles about this case or anybody involved in it. You can't look at any kind of social media or any other kind of accounts of this trial or anybody involved in the trial. Essentially, you're still on jury duty. I am going to, for the next hour or so, keep y'all around here. And Sergeant, maybe, I don't know, I'm sure there's probably another jury room that they can retire to. While y'all are on jury duty and the jury is deliberating, I want y'all to stay within an hour or so of this courthouse. If we're ever on a break, you know, we've got Thanksgiving break coming up. Obviously, y'all can go and do whatever your Thanksgiving break plans were because the jury's not going to be in session, court's not going to be in session, we're not going to be deliberating. But even when you're on those breaks and any others that might occur during the deliberation process, you still can't talk to anybody about the case or allow anybody else to talk to you about the case or look for any information in any way about the case. So essentially you remain on the same instructions, just when we're on break, you're on break too. When the jury is deliberating, I need y'all to be where, if we need you, we can get you within an hour, down here within an hour or so, okay? So for right now, y'all can go and grab your things. You can say goodbye, it's been great. I may see you again to your fellow jurors. And then we'll have you in one of the other jury rooms for a little while at least. And if I'm going to release y'all for the day, I'll let y'all know that. But again, just kind of stay within an hour or so of the courtroom. And just like you've sort of kept your cell phones in a way that we can communicate with you, continue to do that in case we need to. Thank you very much.
Alrighty, so we've got our 4 alternates identified. Probably a crazy feeling there. I see some people asking who juror 56 is, why they're so, like, why we're saying jury 56. That's the juror that sent the email to the court that they weren't able to be unbiased if the state was still presented the way it's been.
Okay. On page 2? Okay.
When reading participation in criminal street gang activity for count 50, you said subsection 1 and not A. So I just wanted to
Hang on a second. Let me get there. Page. Where are you talking about?
So count 50, where it has participating in criminal street gangs,
Yes.
you said section 1 and not A?
Okay. Do you want me to call them all back in and say I meant to say A, or they'll have copies of this out there? And it'll be on the verdict form correctly.
Yes, Your Honor.
All right.
That's fine. I didn't know if I had something different than what you had, and so I wanted to make sure that what I have in front of me was correct.
Okay.
Only as to page number 9, when you, last paragraph, any out-of-court statement,
Hang on. Yes.
as we were reading it, the thought came that maybe we should add any out-of-court statement made to law enforcement, or made to the police, made by one of the defendants on trial in this case after the alleged criminal act.
We probably should have.
So just,
I gave y'all this, I don't know how many different times to look at and ask you. I don't know how many different times for any kind of comments or corrections. So what do you want me to do?
can we add it, and then when you send it back,
Just, sure.
that's all, Your Honor. I'm just going back through.
Made by one of the defendants, made to law enforcement by one of the defendants on trial?
Yes, Your Honor.
Okay, we can do that.
And as of right now, those are the only ones that I see.
All right, appreciate it. Thank you. Anybody else?
I have no objections to your reading of the jury charges, Your Honor. I just need to renew my request and objection to exclusion of jury charge 3.01.10, which is the justification, as I requested justification for my client's possession of a firearm by a convicted felon. I requested that charge, so I'm just renewing my objection to the exclusion of that charge, as well as the separate and distinct charge that overt acts need to be proved. An overt act needs to be agreed upon unanimously by all the jurors. I know, Your Honor, stance that you referenced the need for unanimity, being unanimous. I always struggle with that word.
Okay,
Within the jury charges, and I understand that, but I'm just going to renew my objection.
okay.
Thank you.
All right. Then we will, y'all have agreed as to what evidence goes out?
Yes, Your Honor, there is we're including a flash drive with a list of the exhibits, the Stillwell exhibits.
Okay.
And I thought it would be appropriate, and if it's not appropriate, please object. It's just a list of the exhibit numbers, because the flash drive is little, so we can't list them all. So we're printing on a piece of paper.
Okay.
And we're just going to attach the flash drive to the piece of paper.
Okay. And those don't go out, you're just saying you're listing them.
My understanding, well, they can't play them. My
Right.
understanding is that all the media was going to go in the back room. They can't play it, but then they could ask if they wanted us.
Just so they'll have a list of what it is?
I'm not even proposing a list of what it is, as in what each exhibit is, but just that these are the exhibits that are on this flash drive. I'm not suggesting,
We don't normally send the actual media out with them.
okay,
I mean, they
had
can,
this-
it's certainly in evidence and they certainly can consider it. They just would need to say, hey, you know, I'd like to watch the FedEx tape again.
Okay, my understanding, and I had spoken to some members of the state about this. The understanding I had was that the media was going to go out, but of course they have no way to play it, but then they could request.
Okay, are they gonna even, if it all, for instance, goes out in a bin, are they gonna even know what it is? Like, are they all labeled? Yes? I mean, it's fine with me if that's the way y'all wanna do it.
The only other thing we were going to ask to do, and I believe the defense counsel has an objection, we were going to send a legend out with the letters and what letter is associated with what act, so that they would know.
What
We
letters?
organized
I
them.
don't know what you mean by that.
So every act that we presented, so for example, VV was the Shamel Drinks homicide, so that they could know when they pick up a letter, what that was in reference to, Your Honor.
I'm going to object to that, to the state's kind of direction of compartmentalizing the evidence, and quite honestly, some of the evidence that was admitted under certain letters applies to certain other cases. I mean, these aren't distinct. I know that they're charged as distinct overt acts, but Walter Murphy testifies, for
Right.
instance, and he has things they admitted to Walter Murphy might have a WW, just for instance, but what he testified to involved different acts.
I mean, I think that as they were listening to the evidence, they could write down the number of the exhibit. So if they want to flip through their notes and say, you know what, I was really interested in 53 WW, then they can find that, or if it's media, they can ask to re-listen or replay it. I don't think that it's really appropriate to say, here's kind of the state schematic of the evidence. Okay. So have y'all otherwise agreed on what evidence goes out with them and what evidence doesn't?
So I've been presented some case law this morning, and we've discussed it. I don't have any problem with the GBI reports going back. I know that was one bone of contention. I don't have any problem with the ME reports going back. We've been going back and forth about two issues: the CAD reports and the demonstratives. I'm objecting to both the CAD reports and the demonstratives going back.
Okay. You wanna?
I join in.
Okay. All right, does the state feel that the CAD reports or the demonstratives should go out?
Yes, Your Honor, we have case law regarding demonstrative evidence
Okay.
that demonstrative evidence does go back to the jury, and it's not a violation.
They're going to have to craft an instruction on that.
Would you like to share that with the court?
Yes, Your Honor.
Oh my God, their demonstratives are going to go back.
It's like Ruffin v. State, which is 333 Georgia Appeal 793, which is a 2015 case.
Mm-hmm, okay. And then how about the CAD reports? Is the objection, what's the objection to the CAD reports? Okay. And does the state have a position on that?
Your Honor, the state does not believe that the CARE reports are a violation. We continue with this rule, and we are looking, I thought we had the case on point, but we are looking for that case as well.
This is a little crazy that they're doing all of this right now. I mean, this was part of their homework Thursday when they took that early, recess to work on this. But what else is new? What else is new? I just want to get caught up and then we'll go back to normal speed. Yeah, the jury's probably like, we picked our foreperson. What are we supposed to do for this waste of time here? Oh my goodness. And it's like one of those things too, do you want to send the jury back? They want to send the pot of spaghetti back with the jurors.
Okay.
I had a case on it. It's a March 2021 case. I'm going to spell it Pattarozzi, state 385
non-testimonial. A state's demonstrative, non-testimonial.
Cover CAD reports at all, or is it just kind of, here's what continuing witness means?
Oh, CAD reports.
Kind of just what, here's what continuing witness means. I couldn't find a case specific or on point as it relates just to.
It's hard to believe, honestly. You know?
Which leads me to the conclusion they go back.
Yeah.
I thought they were talking about demonstratives. My bad.
So does the defense have any case law on CAD reports? So I'm looking at a case, Muse, from the Supreme Court from last year, 316 Georgia 639, and it also doesn't cover CAD reports specifically, but it's talking about surveillance videos, and it says, here the surveillance videos were not the reduction to writing of an oral statement, nor a written statement provided in lieu of testimony. And a CAD report, I mean, it contains the reduction to writing of an oral statement, doesn't it? So it may be that it can go out redacted?
Yeah, black sheep of fashion, I would say if there's some case law talking about demonstratives can go back as long as they're not testimonial in nature, the state's PowerPoint is like all about putting testimony on the screen. Like, I don't know if an instruction on, you're not supposed to consider this as evidence in and of itself would be enough.
What does CAD stand for? Computer
Assisted.
aided.
Oh. But they didn't answer that issue, right? They came back to this CAD thing, right? The demonstrative thing is still up in the air. But Atkins popped up with, Abadi popped up a case law on the CAD report issue. So I think we're still waiting. I think that's still open. This is crazy. They got to go through all of this right now.
Mm-hmm.
I wanted to share this in case it helps. My thinking is with the arguments we've had on CAD reports and 911 calls, in our many days of going through upcoming exhibits, the court made determinations on testimonial versus non-testimonial with how we walk through and redact it. And so my understanding with the continuing witness rule is if a document is non-testimonial in nature, then it's not a reduction or substitute for the person's oral statement or testimony. In terms of that non-testimonial analysis is part of the genesis of the continuing witness rule. And that was why I wanted to share that. And this is coming from, I believe it's the same case that Mr. Abadi cited, the PATTA.
Yeah.
But I just wanted to share that because it just hit me that that pre-analysis, of course, with the CAD and 911 specifically, we have argued and the court has ruled on that part. That was all I wanted to share, Your Honor.
There's another case, it's pretty new, it's Davis v. State, which is 371, Georgia Appeals 469,
mean, in the Paparazzi or whatever it is case, the continuing witness rule is inapplicable where the documented issue is original documentary evidence or where it's non-testimonial because it's not a reduction of or substitute for oral statements or testimony. It's certainly not a substitute for oral statements or testimony. And it is original documentary evidence.
I feel like I'd just be watching Love to see when she nods.
And I think we already redacted out of every CAD report, at least since I've been involved, any hearsay, right?
Your Honor, it is true, it is, what Mr. Atkins said, to my recollection, is completely accurate, as we did have a series, when we went through these CAD reports, a series of hearsay objections and
They're riddled with bullets.
confrontation clause objections.
Right.
And some were redacted.
Yeah.
They're going to have to line item and make sure the state doesn't try to, oh, you let us send CAD reports back? Let's send in
Right, so then I
wholesale.
think
the
it would
ones you
be my
excluded.
conclusion that it is all right for them to go out as long as they're all redacted to cover the evidentiary rulings that I made previously, or that the predecessor court made previously. All right.
They're gonna need time to go through
I hadn't
that.
had a chance to look at the demonstrative law yet.
Okay, so yeah, the demonstrative thing is still unresolved.
Yes.
I think the CAD reports is going to be an issue because they're going to try to submit something that there's an exclusion, a different basis for exclusion in play. What else would be new? I can't believe that they're actually weighing this. I think this is stupid for demonstratives to be... Like, demonstratives are used... It's their arguments. Attorneys are not supposed to... What attorneys say, the questions that they ask are not evidence. And by allowing a demonstrative to go back with the jury, that's confusing because it suddenly makes something that they put together, it's sitting in a pile of evidence that they can consider. You know, something like Agent Bernie's poster boards, whatever, those can go back. But if they're trying to admit these things that they put together, their notes on the easel, and their PowerPoints, like, hello, they they labeled the slide op hunting. They labeled the slide op hunting. Yeah, this is crazy, Puda Bear. They can't start their deliberations until this information's received, but how long is this gonna take? Atkins looks stressed. Who's playing with the microphones, the aux cables? Rod Factor, thanks for the 20. There he go with them hands. Yeah, as soon as he stood up, he was at it. He was at it. Maurice. Big thank you here to Rod Factor. I love the chat when Atkins starts talking. Like, the chat just goes bananas. Angie Lay says, please show Kat some love. Hit that like button. It's a free way to show how much she's valued and appreciated. Thank you so much, Angie. Oh, let me take this thing off the screen. Got the wacky inflatable tube man going on over there the whole time.
All right. My rating of reference is that demonstratives
Oh, no.
can go out with the jury.
Is Love on the phone?
Y'all, if y'all got something contrary to that.
Can we just be clear what demonstratives we're talking about? 'Cause
Uh-huh.
are they all?
Okay, so just the poster boards. So the Agent Bernie stuff. The little graphic from yesterday, maybe.
I believe there's some physical evidence that Ms. Weaver may have, in her,
She's got guns and drugs.
for the drugs, kind of.
Neither of those is going out to the jury.
Okay.
If you have pictures of them, those can go out. Or you suggest, is there anything besides guns and drugs that she has?
That's what we're gonna look at the
Okay.
evidence list.
Y'all aren't suggesting that either of those go out with the jury, are you?
No, we're talking, we have the jewelry upstairs. And, I
Okay.
mean, some of that may or may not.
Not sure we want that to go out with the jury either, considering the allegations in this case by one of the attorneys. Unless we've got an
What about the
armed
slime
guard in
drink?
there.
We're gonna go over the exhibit list, trying to see what else Ms. Weaver may have.
Y'all got pictures of the jewelry and pictures of the guns and the drugs, right?
Yes.
Okay. And
Oh
those
my god, the aux cord.
are those in evidence?
Some of the picture of the jewelry.
Okay.
While that's being done, I have permission to just step out for a moment.
Sure, absolutely. Yep.
I think that was less of a shade to defense counsel, but more of Paige trying to wonder why Hilton suggested that as her first example. Like, why would you be thinking about putting a
This
bag of
should be pretty-
jewelry in front of the jury?
Excuse me, Your Honor.
Yes.
Regarding Ruffin v. State, having looked at the demonstratives the state plan would like to send back to the jury, these are demonstratives that were, if not all, at least for the most part, I think all, produced by the state for use with their witnesses. Whereas
Okay.
in Ruffin, that was an anatomical chart apparently used. Well, actually, I can't tell if that was, it looks like it was used by a medical examiner in the parenthetical.
So I'm looking at, it's a fairly old case from the late 90s, but it says items of demonstrative evidence. It's Gabbard versus State. Hang on. Let me find that part.
Oh, Gabbard v. State,
Yeah.
Your Honor? 233 Georgia App 122.
Yes.
Let me pull that up.
These were also anatomical drawings to illustrate victims' testimony.
There's a more recent case, Horne v. State, Georgia Supreme Court case 311, Georgia 506. It addresses demonstratives as well as cell phone presentation and things of that nature going back. So,
Sorry,
This
was
is
that
so
Moore v.
late.
State? Thank you.
311, Georgia 506.
Thank you, Mr. Abate.
This is just crazy. Jury's back there twiddling their thumbs. And Curious Coco here says, Paige is being very demure in her reading instead of inflecting on the right portions to get the point across. Time for a slimosa. Heck yeah, it's Taco Tuesday, you guys. Taco Tuesday. And I'm sure it's 5 o'clock somewhere. In the chat, if it's 5 o'clock near you, let us know. I think some of the things she gave an inflection towards, which I thought was interesting and helpful. And remember, that doesn't reflect on a transcript, so it's not really like either party can go and say, well, she emphasized certain words with her tone of voice. The appeals court will look at a transcript and not be able to tell, so a little bit outdated there, the technology, the way we do appeals. And if you're joining late, what's going on here? A hot mess, because there's still stuff to figure out regarding what can go back to the jury. The jury was sent back, I don't know, what, 20 minutes ago at this point? More than that. About 30 minutes ago. Say, oh, go pick a 4-person, right? And don't start deliberating yet, because we got to get you the stuff, we got to sort it out. And here they are looking up case law to argue issues.
This case, Your Honor, I think it seems to imply that the lead detective is the one that prepared the PowerPoint summary that went out to the jury, not a demonstrative prepared by the state. Unless
There you go,
I'm
Doug.
reading it quickly, but it appears to be a distinction there.
Okay, so I'm looking at a case, McKenzie versus State, 300 Georgia App 469. It says the continuing witness rule does not apply to demonstrative evidence designed to illustrate testimony given by witnesses. Here, the documents complained of were designed by an investigator of, it was the DeKalb County DA's office, based on other admitted exhibits, including cell phone records, dates and times that checks were cashed. The documents were admitted at trial and served only to summarize the other admissible evidence. There was no violation of the continuing witness rule. I mean, that was more like a summary document, but I guess that was demonstrative and summary. And it was prepared not by the witness, but by one of the parties, and it was not subject continuing witness. Seems okay to me.
I'm going to have more of a challenge distinguishing that one, Your Honor.
All right.
Yeah, I don't know if I can do it.
So I think unless y'all come up with something else, that I'm going to overrule the objection to both the CADA reports as described, redacted, and demonstratives going out. Other,
There are some piece of physical evidence, Your Honor, hats,
okay,
other clothing items
yeah,
that we're having someone go to retrieve to bring them down.
okay,
And I think by the time we retrieve that, gather everything, we'll be ready to
all right.
collect everything and have it sent back.
One other matter, there are 2 demonstratives that were admitted by Mr. Steele.
Okay.
These were admitted at some point during the trial?
So I'm,
In January?
yeah,
I don't-
those are just blow-ups of
Yeah.
the language of certain
Yes, Your Honor.
overt acts.
It was admitted when Trontavia Stevens was on the stand. I don't particularly have a strong feeling one way or another about them going back. I'm not sure it's appropriate.
I'm thinking those aren't needed because they're going to have the indictment itself out, and that's really just a magnification of certain of those items on the indictment. So we won't send those out. And if y'all want to look through whatever other demonstratives there are, that might be a good idea. I feel like I asked y'all to do this several times, several weeks ago.
They just went through it, I believe, Mr. Atkins is telling me.
All right. Okay. Well, good. Thank you. So, I keep. Can you do that? Oh, God, has it already on this one? Yes.
The state has used demonstratives for the result of his writing during testimony.
Right.
I I don't believe that those are covered under the case law that we're talking about. This is just literally writing in trial. I don't think that makes it a demonstrative. Essentially, they
So
were
the
writing
easel's out?
words of jurors, right, is kind of the way I saw it. Sending a message, write this down because it's important. But I don't believe it's appropriate for these to go back.
Thoughts? I mean, it didn't seem like that was being used to help the witness illustrate their testimony. It was more to help the jury kind of. We agree. Okay, so those will not go
Wow.
So
out.
I'm gonna put these right here.
Wow. They actually said we're not going to argue on that. They were talking about the notepads, the giant notepad that they put up on
All
the
right,
easels.
let's take, y'all can continue to do this. Let's take a quick recess though.
Paige is
And
hungry.
y'all do that during the recess and then maybe we'll come back and once it's settled, okay?
All right, so we're like 30 seconds behind. We'll get that caught up. So you heard that, guys. Get your snacks. Get your snacks. And I don't know. I guess we'll hang on and see if we get any more. We'll talk about some stuff. We've got some stuff to talk about. And we'll make sure they close up these loose ends. I don't think, I don't plan, I know others will probably do it, and you'll probably see me in a chat somewhere else. But I don't think I'm going to sit here for jury watch, for verdict watch. I will go live the second that we hear that there's a jury question or a verdict is in. I'll jump on a live stream. So make sure you're hitting that bell, right? Next to where you subscribe to this channel, there's an option to hit a bell and get all notifications. You don't need to keep that on forever. But if you want to put that on to get the notification from YouTube when I jump live, when there's a juror question or a verdict coming in, you'll get that notification. But we'll stay on for this and see this final cleanup, right? These things that should have probably been taken care of already that we're doing now. We'll definitely get through with that. But just as a heads up, I don't think I'm going to sit here, especially if they're going to deliberate for a while. I'm not just going to sit here on a screen. I'll be hanging out somewhere else. So, also wanted to give a big thank you here to Brandon Flowers. I think this is the face with the money symbol sticking out of it. So big thank you here. Coitus says, I'll watch Traffic Court if you stream it. Now, hey, I did follow the Corey Harris saga. The guy that went viral because he went on a virtual court appearance in front of Judge Cedric Simpson, the Honorable Mr. Simpson. And it was traffic court for driving with a suspended license. And he was driving and pulling into our parking space on the Zoom call. The judge is like, are you driving right now, bro? What are you doing? And then it turned into this whole thing because it turns out he's never actually had a license and there was a clerical error and it ended up being a whole story. So I have actually covered traffic court before. Lo and behold. So there's that. It was a good one. That was a good one. It was a heartwarming story at the end. But yeah, regular traffic court, I don't know about that. I do like a lot of civil stuff. So I know civil law seems boring to people. I think a lot of it's interesting. I think Depp v. Heard was incredibly interesting. So more cases to come. This is not the end. I'm definitely going to follow along. Again, there's a status hearing, a status conference on December 3rd, which is the Tuesday, next Tuesday, a week from today. Paige Whitaker is presiding. It's in her courtroom. And it's for the remaining co-defendants here in the YSL trial. So I don't know if that'll be streamed, but I feel like maybe it will be because this is still such a big deal and has a spotlight on it, even though it's different defendants. So we could watch it if that's streamed, of course. If not, we'll figure out how to do a video after using the news from text-based publications or from Twitter. So we'll definitely keep following news here with this YSL indictment. But yeah, this isn't the end of the channel, but I understand that, the stuff I cover might not be everybody's cup of tea, but hope whenever I run into anywhere somewhere else, it's a good time. Say hello. Mike the Mob says, I think it's about Hilton. She got real hood yesterday lying and pushing theories, and I think she half love and half woody. We needed love to make pow sounds. Heard she was crying. Yep, I think it was Kathy Roussan that posted that. Well, let's actually just pull it up so I'll get that right. let's see, yesterday. All right. At one point during prosecutor Simone Hilton's rebuttal closing argument, Donovan Thomas's mother started crying. Once court was adjourned, Hilton and Shamel Drink's mother hugged and both had tears. So there you go. There's a little bit of inside the courtroom, like what's going on inside the courtroom yesterday after Hilton. But yes, heard that too. That's where I heard it from, and those are the details that I heard from Kathy Roussan. Interesting. And I think it's interesting that Hilton got the hug from Shamel Drink's mom, and we've heard at least an aunt say they don't think that the state did a good investigation and they might not have the right guys. So, but family members can have different opinions from one another, and victims can always have their emotions. And honestly, you could cry even if you think that the state prosecutor didn't do the right job or investigate well enough. So I don't really read too much into that. No judgment here from this channel from the victims, unless, every once in a while you get some story where a family member seems like they're just going above and beyond and doing too much, like maybe trying to capitalize on the death of a loved one, and maybe they don't care about the death of a loved one. So every once in a while I might criticize something like that, but other than that, I'm all hands off. I don't really like to talk about victims' families. I think the way they deal with their grief, they get a extra grace from me. Do not look at them the same way that I would look at a prosecutor on this case, for sure. Thank you, Mike the Mob. Survivors Speak says they have a new RICO trial coming after this one. Is this the Cop City RICO trial? That seems like a hot mess. I mean, I already saw that there, issues of the filter team, the taint team, got to give the chat the taint word here. They're not filtering correspondence that could be protected by attorney-client privilege, major issues. And again, with a RICO case, you shouldn't make these mistakes. You shouldn't make these mistakes for any case. But something as basic as respecting, like, attorney-client privilege. Get your ducks in a row and don't mess up the basics. Because that's exactly how someone that actually did break a law, did commit a crime, did harm somebody, can get off on a quote-unquote technicality, right? We don't need to use these means to an end that lack integrity and don't follow basic rules of procedure and honor basic rights. Just do the basic things right, especially on a RICO trial. Like, imagine the resources you have devoted to this, and you're going to tell me you're messing up not having a filter team, filter communications that could be privileged. Just stupid. So I hope I'm getting the right trial here. I do think Cop City, I've got to get in the loop on that, a little bit out of the loop, but I have heard some like, here we go again with just the shenanigans. So don't know the facts of the case, but heard it's a mess. What else is new? What else is new? Oh, okay, Survivor Speaks, thank you, says it's supposed to be a joint effort with 3 or 4 different counties in Georgia. And that's interesting because as far as criminal street gang activity with RICO, which might be a little different here. I don't know if this is just like racketeering or if they're charging criminal street gang activity. I don't think criminal street gang activity is part of this Cop City case, but maybe it is. But as back to YSL and this RICO for YSL, which involves allegations of criminal street gang activity, all the press surrounding it in the early days, right around the time that this indictment dropped in 2022, Fani Willis was going in front of the state Senate. She was at these hearings and she was asking, look, here's these bills that you're proposing. We want additional funding, additional power, broader discretion to prosecute. We want to be able to go across county lines for these prosecutions for RICO and for criminal street gang activity related charges. Right? So in a way, we've got this similar expanding scope. We've got this lens that at least back in 2022 and 2023, politically, there was a push to expand that prosecutorial power. So big implications here. Again, one case isn't ever isolated to just being its own case. The implications from one case could end up impacting someone else's case. So even if something seems uninteresting, doesn't mean it's insignificant. And I think this one actually seems interesting. It's just a lot to try to keep up on. Also, you saw me quote in the chat, I was pulling it up on the screen, Joseph Papp, or Bapp, I don't know how to say his name, I gotta ask him. But he works for AJC, the Atlanta Journal-Constitution, does really great coverage, and him and his colleagues have done good coverage of this Comp City RICO. So I recommend, again, if you're using X as a platform, check him out. It's a good way to get the short updates. They go in person to the courtroom and give these quick updates. So sometimes Joseph isn't always in the YSL courtroom. He'll be covering other cases, but he'll be live tweeting updates when he can. So every once in a while he covers Cop City. So definitely a good person to follow there. Okay, so they are doing gang related here. Thank you, Survivor Speaks is on it. Shout out to Survivor Speaks. Make sure you guys are giving Survivor Speaks a follow. Another creator, incredibly well informed here on what's going on here with the Fulton County shenanigans. Let me get this link. It's going to make me do that weird buffer thing when I pull her up. But there we go. And I will say, you know, I'm only one person. I like to do deep dives. I like to, it's not possible to do that for every single trial that's happening everywhere in the world. However, if there's something like a case of interest, just because I don't have the bandwidth to start covering it, doesn't mean I won't point out like, hey, here's where someone else is pulling out the information. Here's a place you can find those resources. So always feel free to share that stuff in the chat here or over on X. Thank you so much again, Survivor Speaks. Touche says, can you imagine after all this if the jury came backward with a question about evidence that wasn't ever admitted? Who would be surprised? And then you said this earlier. We were talking about it in the chat a little bit because the stream was going. And then look at this mess that we have happening with the demonstratives and the CAD reports. Oh, we can let the CAD reports in. And Charlotte goes, hold on, wait a minute. You know, there was some other exclusions, right? Some of these CAD reports had, you know, hearsay. We didn't find that there was an exception. So certain stuff was redacted or excluded. So we can't just wholesale plop this in front of the jury, right? So this comment here, Touche, we saw it play out here over this break that we're currently on. We're still waiting for a full resolution. Holy moly, this case. Start pushing weight again says just because you're skinfolk doesn't mean you're kinfolk. And, you know, the jury makeup here, hold on, I'm going to back out because I think they put it in their description. Let me go back to law and crime. All right, so jury makeup, and even though we know they've had this count wrong, they've like copied and pasted the YouTube description for a very long time. They've only had 4 alternates for a while, but they've pasted this description for weeks. So, but as far as we know, not including the alternates, there are, and I wonder how they knew. So they must have known. They must have known alternates. But 7 black women, 2 black men, 2 white women, and 1 white man are apparently the 12 that will be deliberating, according to this non-updated law and crime description. So let's get this back up. There we go. So I don't know. But going back to this comment here that just because you're skinfolk doesn't mean you're kinfolk, I do feel like, and maybe it's not my place to speak, but I do feel like Hilton went in there with that expectation that maybe match the energy I'm bringing because we are kinfolk. And that's really the most I can say. I'm not a juror, and I'm also not the same skin color as Hilton. But I just felt like she had that expectation that there would be that reciprocity there, the way she opened her closing rebuttal statements yesterday. So, and thank you so much here. Sheriff Chuck says, if I watch someone for 165 days and on the last day they became a whole different character, it might get my attention in the moment, but after the emotional response, it will go away. And I'm struggling a bit to remember some of the things that she said. And I really think I have decent recall, especially I take notes. And we talk about things in the chat. If we're commenting on things in the chat, it reinforces a memory of the things that are being said. And I'm losing the details of what she was saying and remembering more how it was said. So I think this goes to what you're saying here, that, you know, that emotional response captivates your attention, but at the same time, it goes away because the things that are being said underneath the emotional tone, you're not really absorbing the words. So I think this is valid. I feel this personally, trying to remember some of the stuff, thinking about it last night. You know, I can like hear it and imagine the visual, but I'm not remembering the words. So, and that's crazy, you know. I think trial science is so interesting. You know, I'm not an attorney, but I think, you know, the same way that you hear a star athlete talk about these nuanced things that they do for their routine. Even certain like rituals, like a baseball player, sometimes there's rituals that they do where they gotta unstrap the glove 3 times, take the glove off once, put it back on, tilt their hat, then go like this with their bat 3 times before they step up to the plate. You know, all these little things. There's a huge thought process behind how you deliver in the moment, right? So there's a lot of stuff behind trial science research, how to be captivating, how to use storytelling. You know, we see Jay Apt in his opening for Diamante Kendrick uses Krispy Kreme donut reference. And he says it so many times, and it's making you hungry while you're hearing about it. But we know that when someone says donuts, there's a big hole in the middle. Something's missing. Just like that Atkins PowerPoint slide where he's like, oh, it didn't load yet. But all the stuff on the outside is what you're not supposed to consider. And the stuff in this circle in the middle of the donut hole is what you're supposed to consider, the evidence. And nothing loaded on the screen. It was an empty circle in his PowerPoint slide. Well, that's hilarious in this trial, all things considered, that we have an empty circle. We have Diamante Kendrick's attorney's opening statements referencing Krispy Kreme donuts, and this case being a donut hole. He says it like 7-8 times during his opening. And then Doug brings up that Krispy Kreme donut again. So when you play on something being memorable, there's a way to do it where the meaning of why you want it to be memorable. Sure, it's comedic, it's funny, it might make you laugh, it might make you hungry. And that laughter, that hunger can reinforce, you know, you have an effective reaction to it, it can reinforce your memory. But your memory of why he's talking about a Krispy Kreme donut as a metaphor, what it means about how the state's going to present their case to you, the words were not lost on me just because I was busy thinking about a Krispy Kreme donut. However, with Hilton, the meaning was a little bit lost to me. And then she gives this bike story. She gives this bike story with the sand, which you guys are like, she got the story wrong. So shout out to STS and you guys in the chat that gave me the punchline when it was blocked. You know, I think it can be very effective to use anecdotes, quotes, give us some type of mental heuristic to illustrate, demonstrate, bring to life something that might be more complicated to understand in a dry, explanatory fashion. And Hilton gives this like a hee hoo ha story, like it was a personal story when it's a punchline joke. And I don't think that was memorable, except for why was she doing that, right? So, so you know, what else is new? There's a way to do it that works, and there's a way that just looks like you're trying to do the things that seem like good trial science, and it's just not actually a good application. So there we go. Sheriff Chuck, oh my gosh, that was a horrible one. My apologies. All love here. But yes, it'll go away if it's just an emotional response. Danny IRL says, I got a vision of the state standing over... This is so hand in hand with Sheriff's comment. I got a vision of the state standing over the jury, wagging their finger, saying, use your common sense. I'd feel insulted. Yep. That's how I'd feel. And in all seriousness, this wasn't just Hilton, right? Atkins had the extended pointer finger, right? He had that long pointer stick, and he was saying, use your common sense. So it seemed as a team they got together and said, let's emphasize this punchline. Let's tell them that it would be against common sense. In other words, it'd be stupid to come to any other conclusion than that you should find guilty on all of these charges, right? Playing on my intelligence, saying that that's it, just come back with a conclusion of guilty, right? So a little bit, if you don't deliver this kind of push in the right way, it can come off as insulting, offensive, and could put someone on the defensive, right? You're not going to tell me what to do, right? Those are real things. Those are real things. Peter Ortiz says, Kat, I love the hat. When you were done with the stream today, kick back and have a margarita. Thank you again for this. I've got so much work to catch up on, but I love a good Taco Tuesday. Love a good Taco Tuesday. Haven't had one in a while. I've done taco nights, but not on Tuesdays. It'll be like Wednesdays. So this sounds really good. This sounds really good. And not exactly, I don't know about a margarita, but have you guys ever had a Mexican mule? It's like the ginger beer and the tequila and a little bit of lime, and it's so good. Florida's usually really hot. They give you in a nice icy copper mug. So good. It's so good. Andrea says she's getting hibachi. Love that. Love that. Thank you again to Peter. One happy white girl says today starts the most stressful part of this trial. Yep, and I know everybody's like, quick turnaround, the jury's going to walk right back out there. But at the same time, I do think, out of respect for the 12 people on this jury, I do hope that they're taking what they're being asked very seriously. And they've got a lot to go through. The state seems to be wanting to send them back every single piece of spaghetti that they possibly can. So there's going to be piles and piles of evidence. And maybe that'll backfire, right? Maybe it's been 160 something days already. That's overwhelming. You ever just see too much and you walk away, you just throw your hands up in the air, your brain doesn't even want to deal with it. There's no eating the frog, right? That's the term, do the thing that's trying to jump away from you. Do that thing first thing in the morning, get it done. It'll help with your productivity. And if you can't find the frog because it's buried in piles and piles of stuff, what do you do? So, I don't know, the state might be overdoing it. They might be overdoing it a little bit. Not quite on jury watch. They're on a break. And we're waiting to give them the final, here's what you're being sent back with. They said they got like 22 more minutes before they come back. So we've got some housekeeping issues that should have been taken care of last week. They've got to tidy that up, and then they'll officially send the jury for deliberations. So, let's see. And this is super nice here, Sherry. Love this. Thank you, Kat and Mods, for everything. Super nice. Thank you so much, and thanks for being a member for 4 months. That's a long time. We're friends now. Angie Lay's gifting a membership out here. Angie, you're so sweet all the time. Super happy to have met you through this trial. Can't wait again, guys. I cannot wait to see you guys in other random chats. Especially, I know a lot of you guys, we see each other over in, Flesh of the Gods, Survivor Speaks, Mocha's Me, Classy Beats. Like, we see each other in those chats. But I can't wait to be somewhere kind of random and run into one of you guys. Just be like, hey, what's up? Like the Ryan Hall y'all chat for weather, or like a gaming channel one day. Just say hi. Always feel free to say hi. Michelle says, judge said 3 or more persons, but only 2 are on trial at the moment. And I know, Michelle, I love this little thought here because it seems stupid, and it's like, well, obviously there's the unindicted conspirators, they don't all need to be in this room. But at the same time, the stuff that's right in front of you, the information right in front of your face, can be a lot more significant than that rationale to remember, hey, we've got all these other names we can think about. And I think it's important to remember there's only 2 here. Are they working with each other? Did they do this? Oh, there's other names on the indictment still? I think that this is ultimately very helpful for the defendants, because if the jurors are back there feeling like we need to say somebody did this thing, somebody had to have done it, if they're anchored in that, well, having these other names on the indictment when they're only being asked to decide on the 2 people in the room, they have an alternative path to say, well, that guy can still take the fall for it. There was some evidence presented that it might not have been these two. That's reasonable doubt. We don't feel like we're doing an injustice to the victims by not giving them a conviction here. And we hope that one of these others is actually the one. So I know they should be deciding this case based upon the reasonable doubt standard, but guys, juries, humans can be unpredictable. And I think this is ultimately helpful for the defendants on trial, that there's other names, other outs, if you will, on this form that's going back. So, interesting trial, because that's not something that would really be the case in a case with a single defendant, in an indictment with a single defendant. Thank you so much, Michelle. Great thought. Marb, the producer, says, I'm not gonna lie, this is during jury instructions readings. Paige lost me 10 minutes ago. She sounds like she's saying the same thing over and over again. The jury is just gonna check any box. And this is a concern. You never know. You never know. And I think it's, what was the exact time on jury instructions? 50 minutes? Just shy of 50 minutes. It was like 49 minutes and some seconds. So how about that? Honestly, bravo. Bravo. Because they didn't go through and read all the overt acts, thank goodness. But I think that was pretty good timing, right? I was thinking about 2 hours, and they did it in half that time. So, hey to Walter Waller. And Deja Jones, I'm sure they chose a 4-person within this time. It's just they're on lunch, so... And we might not actually hear that directly, but maybe they'll come back in and, hey, now that you've chosen your 4-person, we'll get the acknowledgement that they're done. I'm sure they're done. But we are going to be sending you stuff back, so you can start your deliberations. We'll get that, like, little go-ahead. And then that will be it for what we're able to see happening in the court until the jurors either have a question or a verdict. So... They just haven't given us an explicit update, but I'm sure they have. Jennifer Devine says, if she sent 56 home, juror 56 home, they would riot. Hey, chat. Hi, Kat. Hey to Jennifer. Yeah, I think the whole chat was like, oh my gosh, juror 56, juror 56. And when she read those 4 alternate numbers that were not that juror, the chat was rejoicing. And remember, if you're joining late, juror 56 is the juror that sent the email to the judge like, hey, I'm not sure if I can, with the way the state's been presenting their case, I'm not sure if I can, you know, be unbiased. And the judge had to reassure this juror that, no, we're going to wrap this up before the holidays. So, be awesome. It would be awesome to hear that they're the 4-person. I don't know if we'll know that right away. If they do get on the record to tell us, and it's juror 56, I'm sure the chat will go bananas. So we'll just have to see. Let's see. Did they... Hold on, Brian B. I want to make sure I'm getting this right. The judge has the co-conspirator statement to fix or fixed as well. So we're waiting on an update on this. Which clause was this? I mean, I'm sure if you're saying to fix, I think we'll get the answer when they come back around in a few minutes here, so. JH, thank you for the 3 and showing so much love here. Thank you for the nice words in the chat too. Very appreciated. Mocha is me. This is like one of my favorite comments. I can hear you. I can see you saying it. State is last minute, even at the very end. like, come on now. Oh boy. And you guys know the drill. Loving seeing more and more people show up to hang out on the weekends when Mocha does her streams. Loving it over there. I hope you're feeling better too. And let's see. So this weekend, as you guys are getting tired of your Thanksgiving leftovers if you celebrate, if you eat lots of food on Thursday, this Saturday, we'll be getting together on Mocha's channel, hanging out here doing a recap of all things YSL this week. It'll be a good time because she'll be talking about these closing arguments. So definitely come hang out with us. It's really fun. Let's see. K Grammar, thanks for being a member for 3 months, and thanks for your message here. Thank you, Kat. Dear Will Christian says, great summary of the case, KNW. Thank you. Well, thank you, Dear Will Christian. This is 1 o'clock, so this is like 15 minutes ago. Was my summary just calling this case a hot mess? And you're giving it the thumbs up. We'll go with that. Thank you. So good to see you. Hold on. I'm seeing also hand in hand. I'm dying laughing. Lil Mike and Quez they have made an appearance. But you guys, if you guys don't know who Dear Woke Christian is, especially if you like more Fulton County news, Dear Woke Christian not only covers YSL trial, but does deeper dives on some Fulton County content as well. He's boots on the ground. He's local. He's been in the court. We saw him apply for his Rule 22. Jason Whitaker. I was like, what's his last name? I think it's the same last name as the judge. But no relation. No relation, maybe. So if you don't already know DWC, here is his link in the chat to go give a follow and check out some of the content over there. And this is still killing me. I'm so happy we got a Lil Mike and Quez reference yesterday. Hey, I'm confused. Will we get the verdict today? There's no telling. There's no telling. I would say don't expect one, but it's not possible, right? So there's no telling. Nobody has we won't know until they've sent a note to the deputy to tell the judge that they've reached a verdict or are unable to reach a verdict, and to which they'll probably be told to try again at least one more time. So we won't know. We won't know until we know. Love this name though. Love the name. Tommy Nolan says, vote number 56 for leader of the Wolfpack jury gang. And then we have a shout out to Jack. Shout out to Jack. That was Glanville's dog. That is Glanville's dog. I don't mean to say was to imply anything. I'm just thinking that not in the courtroom anymore. So past tense in my mind. But yeah, Jack a black lab, right? Labrador retriever. So shout out to Jack. And hilarious reference here with the Wolfpack jury gang. Doug is so hey, you guys are wearing lots of blues and grays. Are you a gang? Like, shout out to Doug. Let's see. Jennifer Devine says, what about the OnlyFans chick who offed her boyfriend? So I am actively covering the Courtney Clenny case. We watched one of the recent motion hearings, I think in the beginning of November, maybe the end of October. There hasn't been much of an update other than that. Let's see. I'll pull up the docket and double check. The next thing is a status hearing. They still don't have a trial date. Let me pull that up and get an update. So I am covering that. It's just so spread out and taking forever. But I'll be streaming that one. When the trial goes live, we'll do a live stream watch. Let's see. All right, so their next hearing date is Monday. So the 2nd of December for Courtney Clenny. And it's just a status, so we could hear something like, hey, a trial date's actually set, or it could be hey, we need more time. We don't have anything to update you with today. So who knows? I will post an update on that after that hearing takes place. Probably won't be a video though, until there's actually something more substantial. Sheriff Chuck, thanks for being a member for a month, says, thanks to Kat, the mods, and the chat with the capital C. Great to be here. Well, thank you for being here. And then Classy Beats says, it's up to you, 56. Yeah, we got to get some jerseys going. Some juror jerseys. And also, you guys know, before I go on my Classy Beats spiel here, because not today, but tomorrow's Wednesday, we'll be hanging out at Club Classy But can you guys show some love for Classy Beats? Look what Classy Beats did. That's 20 gifted memberships. So 20 of you now have access to the Viverito custom chat emoji. Make sure you guys are using that to your heart's desire. Again, I gotta say it, it's crazy, but yes, Viverito, the bush thing is her own words. She said she hides in the bushes and observes Cleveland Avenue residents in their natural habitat. So that's not just some exaggeration or a chat meme. It's not a hyperbole from the chat. It's a real thing. It's a real thing. Am I muted? Are you trolling me, Biff? You guys can hear me, or is Biff, is it you? Or are you trolling me, or am I really muted? Okay. All right. I was not in the middle of my Classy Beach spiel and the Bush's Viverito thing. But always, thank you so much, Classy Beats, for coming in and supporting this channel. Always. You guys are so... Stop trolling me. The chat. Just let me show my love for Classy over here. But really always makes me feel welcome when I come over and hang out in his morning shows where he talks about cases like YSL. I'm going to protest the chat if you guys keep saying that I'm muted. Oh my goodness. Let me get Classy's link because we're not doing this muted thing. Let's see. There we go. There we go. Classy's link is in the chat for you guys. If you keep saying I'm muted, I'm gonna blare your eardrums out. And it's not even Biff. It's not even you, Biff. The rest of the chat jumped on the bandwagon. They're like, we're gonna tell her she's muted. Oh boy. Yeah, I think the jury, I mean, they may have been told, like, you can take, if you remember yesterday, I know a lot of people, if you didn't tune in for 12 hours yesterday, at the very end when Hilton got done, Whitaker said, okay, go home. Remember, tomorrow is going to be a shorter day, jury, so don't expect a full lunch break. So she's giving them a short break. They're probably able to go to the cafeteria for this, like, 35, 40 minutes. They're supposed to be back in 8 minutes. So... Gwennon, thank you so much. Oh my god, I'm sorry I keep saying Paige. The more I tried to stop saying Paige, it had the reverse effect. Gwennon says, thanks for being a great host with the green amphibious emoji. Hashtag verdict watch. Heck yeah. I'm sure... Classy, are you doing verdict watch streams while you're in here? Let the chat know if you're doing verdict watch, like if you're doing like longer streams. Are you just gonna do like your usual morning show throughout the week? Because I don't really know. I mean, I'll share if I see someone doing like all day verdict watch streams, I'll share. But, you know, definitely don't want to... I feel like if I have a stream running for verdict watch, like people will constantly think like they'll see it and they'll think that a verdict's ready to come in, and I don't want to deal with that. So, all right, okay, so Classy's doing the usual morning show tomorrow morning. So see you bright and early because I can tune in. Unless the verdict comes down right when you're doing your morning show, then I'm going live. But, you know, if we're just hanging out, I will definitely be over there in your morning show tomorrow. Very excited for the downtime over here. Rebecca Get It and Go, love this name, says 56 had a lot to do with speeding this trial up. I think so too. I really think that the state finally listened to something. And part of that was probably because they had, you know, different people calling the shots and the strategy here. So with Love, I feel like she would have been like, oh well. So shout out to Juror 56. KL says, everyone show Kat some love and hit that like button. Thank you so much for the reminder, KL. And thank you everyone that's hit that like button. Remember, you can hit it as many times as you like, as long as it's an odd number of times, right? Because an even amount will undo the like. We don't want that. Thank you so much, KL. Janky Grandpa, favorite grandpa, says, thank you, Kat and crew, with, oh, is this a dragon emoji? So we've got the generic green amphibious emoji. And then we have the super reptilian, the final boss. So love this here. Love the emojis. Love that I can't look at emojis the same way because of this trial. Have you guys used an emoji that was big in this trial in a random conversation with somebody and just felt like you're bursting at the seams to blurt out your thoughts about this trial to some random unsuspecting friend that has no knowledge of this trial, all because they used an emoji? A whole time. Trey Lee is out here planting potatoes. Love that. I tried planting potatoes this year and I thought that they weren't growing, so I yanked them and they were like baby spuds. I messed up. They were growing and I just doubted them and I ruined it. But it was really cool. It was really cool to do. So this is cool that you're out there planting potatoes. Love to hear that. Shout out to the gardeners in the chat. But be careful now, right? What was Paige, that clause that she really did not seem like she wanted to read, that clause about the possession of marijuana? It was like, it could be seeds, it could be it could be plants. She really seemed like she was embarrassed to be reading that out loud on the record. So just be careful depending on what you garden. Be careful what you announce online. Let's see. Brian B says Glanville just called, said love can go back with the jury. They would walk right back out of that room. Imagine you go in that room, you see that love is sitting there waiting to talk to you. This would be me. Oh, nope, leaving. Turning right around. Made up my mind. Not doing that. Shout out to the ghost of Glanville. Thank you, Brian B. Paulette C says, thank you for helping us get through this trial. You've helped me understand so much. Love to hear that. Love to look up and learn new stuff. So anytime, happy to learn something along the way. Thanks for being here, Paulette. And then Ike. Show some love in the chat to Ike. Ike, you have been doing so much commentary in the chat, right? For this entire trial. Like ever since we started doing like the live streams, you've been in here with great insight and also very funny commentary as well. So thank you so much for showing me appreciation here. But I want to say thank you right back. Ike says, Kat, if this is our last rodeo together, I want to say thank you for your expertise and wisdom. Gotta thank the X-Men. Shout out to the mods for keeping us civil, and my personal appreciation for keeping us well informed. You're a class act, and I wish you all the best. Aww. Ike, this is so nice. This is so nice. And I always have an appreciation for people that can articulate stuff like this. Because I get blathermouthed. I'm just like, I love and appreciate you. And I always admire people that can put stuff like this into words and hope that I can give the same appreciation back, make it clear and understood. So really, from the bottom of my heart, thank you, Ike. And can't wait to run into you somewhere else on these YouTube streets for sure. And if you like another case that we talk about, you're always welcome back. So show Ike some love in the chat here. Been with us for the long haul. Hanging out, helping us get through the very weird, awkward, painful moments of this trial. Look at all this. Look at all the Ikes going on in the chat. Oh, I like Ike. That rhymes. I like that. And someone's saying SteffJK needs to make cupcakes. Heck yeah. I vote yes. If she's down for it, you know. Look at that. All the love. Look at all the love. And yeah, the YouTube chat sphere is interesting. And it like kind of reminds me of like, you know, when you go back to the channel, it kind of reminds me of like almost like a persisting chat room, but except it's not persisting, right? It's only there when that channel's actually live or running something. But like the old days of when chat rooms were the thing, or like even forums, but with a live chat aspect, right? It's like little micro communities that center around the channel, but like the chat, you guys are like so much more than just me, right? This would not be the same without you guys. So it's just a cool thing that YouTube has, the whole chat. Like, awesome feature. Cool to be on the other side of it. Love being part of the chats all over here. Jennifer Devine says, this is a trick. However, there is no way prosecution redacted what they were told to. I mean, look at the Wooney Lee thing. Somebody in the chat pointed out that Wooney Lee paper exhibit wasn't redacted. So we couldn't get that right. It caused a significant mistrial motion. It's where this plea deal avalanche spiraled out from. So can we trust the state to know that they've redacted everything properly? And I don't know, imagine there's a longer delay, right? What if the jury can't start deliberating today because they still got to figure out what they can actually send back in the deliberations room? I feel like if this is the state's fault, then the jury should find out that that's the reason why. I feel like they'll just leave it vague, and maybe the jurors can infer the reason why, even if they're told not to infer it. But come on. Come on. And Whitaker did kind of bark at Hilton a little, saying, you know, you had all this time. I asked you to do this. So, yeah. Kay Jules says, you lost me at can we trust the state? Yep, just the cutoff right there. Okay, and Kevin, I think it might have been you. I think it might have been you that said it. If it wasn't, and I'm just giving you that credit, just take it. Appreciate you too, Kevin. Lil Mike and Quez became a member. Are you joining as one membership? Are you cheating the system here, Mike and Quez? Oh, love it, love it. Thanks for coming on board. Janky Grandpa says, thank you, Cat and crew. Oh, I did this. I love these emojis. I kept it pinned because I like these two emojis. Lil Mike and Quez also says, so is the trial going to come to an end today or no? So, I mean, the trial's still open until we get to the verdict being reached. And then, you know, jury will be dismissed when they've done their job. However, as far as like having stuff to watch, I mean, courts, we're not going to have the attorneys and the judge doing stuff while deliberations are underway. The only time we'll have like live court action is if the jury has a question or they come back with a verdict or a note telling the judge we are at an impasse, we've tried, but we can't reach a unanimous verdict. So that's the only action we'll get after they do this cleanup after lunch. So once they start deliberations, they're gone until they're back. But good question though. Shannon Alexander says, wishing everyone a wonderful Slimesgiving. Thankful for meeting everyone on this chat. Crime K&W Slime for life. I'm here for the next chapter. Heck yeah, we're gonna keep watching these hearings. And maybe we'll get a trial date on Tuesday. Maybe they'll, at this status hearing for the severed co-defendants, maybe we'll get a trial date for them set up on this Tuesday. But we'll keep following that. We'll see what happens. And of course, if any appeal is necessary, definitely going to follow that. A whole hot mess. A whole hot mess. And let's see. So Tiffany says, do we really know which way 56 is leaning? I don't think so. But at the same time, if they said the way that the state is presenting a case, that to me kind of seems like confusing mess. And that would suggest reasonable doubt. However, you never know. And we've seen Paige do this in trial, in my opinion. I think that Paige has done this. You say something a little harsh, right? You're feeling like this. You're feeling like that. Maybe this is neutral, right? You're feeling like this. You're upset. Maybe we'll do it sideways. You're feeling like this. You're upset with the state. So you're over here like, I can't stand them. I can't stand them. I'm tired of this. Speed it along. This is crazy. Well, maybe you feel bad after that. And you feel bad, so you come back over here. And because you feel bad, now you actually give a little extra grace, more grace than you would give, right? So there's a possibility that Juror 56 will be like, let me course correct, let me overcorrect, because that was a little bit harsh the way I was acting, right? So just saying, it's a possibility. However, it seems like Juror 56 was not pleased with what the state was laying out. And we saw the state take precautions yesterday. They had Atkins tell them, hey, these are things that you're not supposed to consider. In the jury instructions today, we have Paige read out, hey, you're not supposed to just make these decisions based on sympathy or your perception, your persuasion of either party, right? You're supposed to look at the evidence. So, you know, maybe Juror 56 will fully rein it back in. So, it might not mean nothing. It might not mean anything. It could mean something. Who knows? All we can do whenever we speak about jury, it's all speculation. It's all just speculation. Shannon also says, this slime's giving, by the way, you guys. Court, I think, for deliberations, I don't think court is in session on Friday. So I wanted to say that. I'm not sure. I could be wrong. Maybe, is there a way to just like check Fulton County Courthouse holiday? Do they just like have it on their website? Let's see. Okay, yeah, so no court on Friday either, which means no deliberations. So there's that. And thank you again to Shannon. Mocha is me says maybe Love got kicked out because she said no one can tell the state how to present its case, and the judge and jurors said hurry it up. Yeah, she said don't hamstring us. And there is some truth to that, right? The state, because they have the burden of proof, it wouldn't be right to quote unquote hamstring or hogtie their case, right? They've got to be able to present the things that can show that there's sufficient evidence to establish each element of the crimes as charged. But at the same time, you can't just rely on the argument that you're hamstringing our case because we're concerned about you taking this trial into year 2. Right? There's a difference. There is a difference. And Love loves confusing the difference. So this is a great point here, Mocha. And a throwback there. Shout out to that day. One happy white girl says, why were the jurors not sequestered like in other cases? I think it would have been extremely unrealistic. And I would say the defense probably didn't want to request it. I don't know. I would imagine the state, if anybody requested this, it would have been the state. Because before this trial started, how were all the news reports looking? All the news reports were highlighting on the violence, and this is criminal street gang activity. We have press statements saying that YSL is responsible for 70% of the violent crimes in Atlanta, in the city limits, something like that. Not a direct quote. You know, if I was the defense, I'd be like, well, what else worse could they hear? If, you know, we sequester them, keep them from hearing stuff, they've already heard the news that's coming from police reports and the DA's office. So what's the worst they could continue to hear if we don't sequester them? Are they back? Oh, is this paused? Oh, this is behind for whatever reason. Thanks, chat. How many of you in the chat have 2 windows open? It says we're like 4 seconds off. What? Did they start a new stream? Lawn crime. Okay, let's open up. Let me find a new stream. Well, that's silly. All right. Go to here.
Y'all can just put a joint exhibit sticker on here or write joint exhibit 1 on here. That'll work for that. We've got copies of the redacted indictment to go out.
We do not.
We do not. We still have to sort out those, the language of those last couple of overt acts that we highlighted earlier. So can we figure that out? And do we otherwise have all of the evidence that's going to go out?
Your Honor, there was a challenge during the lunch break to get into Judge Randall's chambers.
Uh-huh. The deputies can get into anybody's chambers.
They just got it maybe about 5 to 7 minutes ago.
Okay.
They're getting the evidence, they're looking for a chain of custody form, and so they're trying to get a chain of custody form.
Okay, well, I mean, it goes from one court reporter to another, so do you want the court reporter to just walk up there and take possession of the evidence?
Yes.
That's probably the best way to do it. Then we don't need a chain of custody form. It just is with the court reporter. Yes, we'll do that. All right, so we will recess for our delightful new court reporter to do that. Thank you, Ms. Taylor.
So we're caught up there. Sorry about making the screen all weird, but seems like they're still not quite ready, but they're almost ready to be ready. And also thank you here, Kiki the Connector, maybe it's Kai Kai. Thank you for the super sticker here. I love it. It's a thumbs up avocado. Heck yeah. Need some guacamole for Taco Tuesday. Yeah, are we really surprised? Yeah, I'm not. I'm not. I don't know what happened to the other court reporter. I thought maybe just a vacation. Maybe she retired. Because remember when Paige first took over, she said her current court reporter in that moment was about to retire that week. So she was only there for like the 2 active days. And then we had the court reporter with the silver hair. I loved her hair. Super loved it. She, I think, went on vacation or was gone. We had a substitute. People were like, oh, do we have another court reporter? But then she was back. And then now it's been the woman who's there today. Christina Weaver made a guest appearance. And she hasn't been back this whole time. So maybe she retired. So shout out to retirement. She's like, I'm inspired by Miss Latner's. Time for me to go. And the difference too, I think, you know, the jury got to take some sort of break, but I wonder what they're doing like right now. This is definitely twiddling thumbs time. Hold on, Juror 56 with the Route 56 profile picture. Thank you for the 2. Shout out for tuning in while you're waiting to figure out what you're supposed to be doing. Oh, man. Yeah, I don't know. And Law and Crime had that little banner saying they were waiting. It doesn't seem like the jurors were even brought back in. Yeah, so really just an update over here on X, exactly what we just saw, that Whitaker just took the bench again. Seems like things have progressed, but there's still some stuff that needs to be done, including getting some evidence. Another break has been called to allow the court reporter to go collect the evidence. So that's what we just heard. No, Brooklyn. This song is like, Last Christmas to me is like what the Mariah Carey song is to everybody else. This is the song that gets stuck in my head. So here we are, starting early. Before Santa Claus has come down the Macy's Thanksgiving Parade, I've officially got a Christmas song stuck in my head. Not technically on watch, because we're still waiting. They haven't started deliberations. We're still waiting for the final ends to be closed up here with what evidence can go back with the jury. We're just waiting. We're just waiting. I don't think Juror 56 is the same juror who couldn't take a job in another state. I could be wrong, but I think that was a woman. And Juror 56 is a man. So, but there is a separate juror, and Juror 387 is the one who she's an alternate. She was named as an alternate. She is the one that got the text messages from her employer. So, I don't know the number of the one who had a job she wanted to take. So, we could go back and like figure out, but yeah, Papa John says, think the jury has already had a preliminary vote, so they are ready when it gets back there, home.
Judge Glanville's chambers is going to, it's apparently a significant amount of evidence. They're going to basically wheel it down here to this courtroom, and
We're getting cards.
Ms. Taylor, our current court reporter, is going to take possession of it. So that'll happen in the next 10 minutes or so.
All right, shout out to Miss Taylor. Miss Taylor, now we have a name. And we're going to get carts of evidence.
Can somebody, I guess I could do that, look in Odyssey and find out the date that's on the original re-indictment to put on this one? You know, when they signed, or who's got possession of the signed indictment? So that might still be, is it in here, or is it still with, is it making its way downstairs? We need the date, so we need to see the. I would think that would be. I would think the case manager would have it.
I'm looking at it.
Right.
I think they're just like hanging out until this
All
shopping
right, have
cart of
y'all
evidence gets
looked
wheeled in.
at the highlighted language for the proposed ways to handle those couple of overt acts as an A and a B?
Yes, Your Honor, and the state had a proposal to, I think, simplify
Okay,
the matter in terms of starting with 183.
okay,
If the state just redacted possession of codeine with intent to distribute and possession of cocaine, because this is the street gang charge, so the jury will still be tasked with the other revisions of did Arnold or Williams possess those items individually. So for purposes of 183, the state proposal is to redact to where it only remains possession of marijuana with intent to distribute and possession of firearm during commission, which tracks the language.
okay. So leave all three of them and have those two kind of offenses only.
Yes, Your Honor.
Okay,
And for 187, the state's proposal is the same, to remove possession of codeine with intent to distribute and possession of cocaine.
okay.
Can I ask a question? So would that mean that we would end up with what?
What is essentially 187A
183A.
and 183A,
Okay,
right?
thank you. That's what it seems to me, and I just want to make sure my
But those
understanding is
wouldn't say
correct.
A anymore, they would
Right.
just say 183 and 187.
Yes, Your Honor.
Okay, yeah, that works if that's,
And the state, and I can email this, but with our previous discussion on the 133 charges and the language, the state, if you stop, like, for example, take 189 or 190,
okay,
if you stop after, an associate did commit the felony offense of possession of firearm by convicted felon, and then redline everything up to where you start by possessing a Glock, and then we would obviously remove for 189 specifically, we would remove the machine gun,
right. Okay,
and then just pick back up, possession of a firearm in indictment, and then cite the felony in the date, and keep it overt action furtherance.
that works as long as, so the question on the floor for that had been, can an overt act be modified to drop it down to a lesser, essentially? Do we have an answer to that?
Your Honor, I'm going to let Mr. Floyd
Okay,
address that with the court, because we do have a,
give me just a sec.
yes, Your Honor.
Juror 56 says, I made it. They let me in. Stay tuned. I love our chat. No, Raphael, so the jury came out, jury instructions were read, but they've spent like an hour, plus had a lunch break, a short lunch break, trying to get together what's going back with the jury before they can start deliberations.
Yeah.
Like a hot mess.
Yes. I wasn't here that day. Maybe I was here when it was.
Ike says, I think jurors need not use some legal algorithm for fairness, but gut intuition and God-given sense, which can't be qualified by court instructions. And I think this is really true. And you can't really override that. You can't know if a juror's overriding that if they're told to override that, right? And this is kind of part of the unpredictability. And I also think because it's not qualified in court instructions, you have a little leeway in your closing arguments to hint that you can't or can do certain things.
Thank you for your
Because it's not spelled out,
Of course, Your Honor.
right?
So the approach we took in this, to try to avoid any problems, was only to remove language, not to add anything. Nothing's been added.
Right,
I want to be clear, is not exactly the same situation, but the most analogous thing I could find in the time available is an 11th Circuit RICO case, United States v. Watchmaker, spelled exactly as it sounds, 761 F. 2nd, 1459 at 1468. It's a 1985 case.
okay,
In that situation, analogous to this, the court found there were certain predicate acts for which no evidence had been presented. It removed them from consideration from the indictment that the jury saw.
right,
That was held not to be a problem.
okay,
And so here, we're simply we're removing actually less, we're actually removing a subset of that, as it references the specific individual defendant in whichever circumstance we're talking about. The others are not at trial, they would have no ground to complain.
Right.
They're not parties.
All right.
So I think it's on all threes at least, but I can't really find a problem with it because we've restricted in this circumstance solely to deletion, not
cart.
addition.
It would seem that, I mean, of course, I haven't had a chance to read this watchmaker case yet, but if they're removing an entire predicate act, that would seem to be more analogous to removing the entire overt act rather than amending the overt act. But again, I haven't read watchmaker. I'm just wondering if amending the overt act, we would be running into a constructive amendment claim, constructive amendment of the indictment.
Well,
Because-
two aspects. I didn't mean to cut you off.
No, please go ahead.
Okay. Two considerations on that, Your Honor. One is the meaning of the word amendment in this circumstance. So if we were changing it to refer to another offense or adding words, that would constitute an amendment. This, to the extent it's an amendment, is exclusively an amendment by deletion. And it is tailored to those aspects where Your Honor found there was an absence of evidence. There's no prejudice to the defendant. It's favorable to the defendant. I'm not aware of anything that says you have to cut beyond the scope of where you found there was a shortage of a failure of evidence. And I don't think there's anything that compels that conclusion. In other words, I don't think this is a throw out the baby with the bathwater scenario.
I would argue that the amendment is actually not favorable to us, that amendment by deletion actually broadens out that overt act. It does not work in our favor because you're removing the
I
elements.
agree, it doesn't work in the defense's favor to make it easier for the state to prove an overt act.
Yeah, and that thus it's conduct beyond that which would appear in the original grand jury indictment, and that would amount to constructive amendment.
Yeah. You know, I mean, even I'm reading Watchmaker right now, and part of it says the court did not change the terms of the crime with which Keating was charged, which I'm not changing the crime, but I'm changing the crime in the overt act. I think the safer thing to do is just to redact the indictment to remove those overt acts. I'm not convinced that it might not be error to do the way you propose. I think logically speaking, it sounds like it should make sense, but in the absence of something that makes it clear to me that it's not error, I would hate to borrow a term from one of y'all, get to, the 90, y'all haven't said it, but almost, I don't know, it was never mind. It was some kind of football field reference that I'm not going to be able to do right, so just never mind. The 1 yard line, and then, yes, y'all probably
I
said 2
thought you were going to
yard line.
say risk introducing further error into this case.
No, I don't know that there is error in this case at all. I don't know.
Okay.
There is typically, there are no perfect trials. We know that. It will be up to potentially some other court to determine that issue down the line. But right here today, I would hate to be on the now 1 yard line and do something that does cause an error that couldn't be corrected.
And
Not letting
so,
him
Your
do
Honor,
it.
If I can respond to that, two points. One,
She's not going to allow it.
it's important, I think, to be specific as to which acts we're talking about.
Okay.
So with 183, there's no change in the nature of the crime we're only talking about striking out those specific things to which there's no evidence. I
Right.
can't imagine any problem from that.
Yeah, no, I agree. I was talking more about the possession of a firearm by the whatever they were, 174, 175, 189, and 190. I'm just going to redact out completely.
Okay.
With regard to 183 and 187, I think those are fine to have just gotten rid of the things that I directed a verdict in Mr. Kendrick's favor on.
Thank you, Your Honor.
And Your Honor, with regard to, I have 2 points.
Okay.
One is, when you're talking about, and forgive me if I get the number exactly wrong, but 170, I think it was 174, 175, 89, and 90.
Yes.
And so with those, the specter that's been raised is, to paraphrase the defense, the appearance of error where none currently exists, as we are at first in inches. However, because of the way you have instructed the jury to handle the overt acts, if they find these, and if there's a defect, those, an appellate court can simply strike them from consideration.
Unless they're the only acts they find.
In which case we would know that as well.
All right.
Because they're going to number them.
Understood. I'm just going to redact them. Y'all will still have over 100 overt acts for them to evaluate. All right, so I am redacting out to delete 174, 175, 189, and 190.
All right, so those were all 4 of the ones that were at issue that we talked about this morning.
Don't know why it won't let me. And then on 183, it will be the language that is now 183A, but it won't say A, it'll just say 183.
And Your Honor,
And then the same with 187. Yes.
this argument may be fixed, but with both of those, of course, redlining or removing, the possession of codeine, the intent to distribute and possession of cocaine from the bottom.
Right.
The last version I saw on 183 and 187 still had those included.
Oh, it doesn't anymore.
I think the state may be looking at the B language and not the A language.
That's perfect, Your Honor.
All right. All right, I think I can't do the rest of it until Ms. Persfield comes back because she has the same document up and for some reason it's not letting me remove the highlights. All right, I see that our mainly physical evidence has arrived from Judge Glanville's court reporter's office. And Ms. Taylor, our current court reporter, will take possession of it. And do you all know what's going out and what's not? Because the jury has had this case for an hour and a half now, but they haven't been able to deliberate because they're awaiting the evidence. And that is why I told y'all for the last several weeks to make a determination about what evidence was going to go out so that when they got the case, they could get the evidence too and begin deliberating. So I'm kind of ready for that to happen.
He's doing something very important. Here are the views of the 3 carts of evidence. That looks like the sticky. Like, holy moly. Oh, this one has the bucket of bullets at the bottom. It's not giving me the full image on this overlay. It doesn't let me.
What was wrong with 180?
I'll go over here. We got the bucket of bullets down here.
Okay, I'm just saying, see if you can open it again, maybe, and see. There's a tiny bit of formatting, but fine. Yes. So starting with like 173, which will be on page 41.
Look at Doug keeping an eye. Heck yeah, Doug.
Right, yeah. So that's going to go to 176. Is that correct? Take out which? Yes.
Can you imagine if off camera Love is just like waving one of the guns around?
Yes. Well, I showed it to them, and then they wrote one, I wrote one. So,
All right, Ms. Persefield has what we think is the final redacted indictment. So with the changes we just discussed, so if everybody can take a look at those, they start on about page 40 or so. Just take a look at those, confirm that they are what everyone has agreed we're going to do, and then if so, we'll print it out, and that'll be ready to go to the jury as well.
Clarification, these carts aren't things that are going back
At
to the
which
jury
time, the
necessarily.
last thing we will be waiting on is the evidence.
This is to transfer custody to the current court reporter. Additionally, some of it might go back to the jury, but they're not sending them like the weed, the baggies of weed, and all of that. So for the firearms, we're supposed to be submitting pictures. Is that one of the jewelry bags? No, it's too quiet. Too quiet. What are you doing, Hilton? Kokomo and Bob's chopping it up back there.
Yes, ma'am.
And they need this evidence for future trials, so.
It's from getting this to the jury. Perfect. All right. All right, while y'all are doing that, I'm just going to put on the record that with regard to the guns and any other physical evidence that's not going to go out with the jury, for instance, the drugs, the DA is the official custodian of that evidence, and so the DA will remain in possession of that evidence, and y'all need to keep that in your locked evidence room. The court reporter is not going to be taking custody of that, the guns and that other type physical evidence that is not going out with the jury.
Now it's getting allegations from stolen.
I know, right? I'm only doing 12 things.
Love is coming to the rescue with her laptop. This is so dumb. I feel like I'm just being nosy, just watching everything that's happening on screen.
Can some member from each team be dealing with the rest of what's just paper evidence and making sure that everybody is on board and on the same page with regard to that?
We've done that.
All right.
We just need to make sure we send them. I think we know we separate things, we just gotta make.
Okay, I am ready to hand all of this to the jury in the next 5 minutes. So
Chop, chop.
whatever needs to get done, let's do it now.
Yeah, those are just.
There, right here. You can put this, I think that's extra folders. That's just extra stuff.
Get it together, Adam. It's like dropping stuff.
Is that the BB charges? They're just extra. You guys want, I don't know anything on. You guys want
This is stuff that's not going back.
that's extra. I don't know what they belong to. It's just extra.
I think it's just folders.
Yeah.
Look, and this is stuff that's not going back.
There's literally, it's just folders though, is what's in that box.
Oh,
I don't know who they belong to. They should just take them wherever they belong to. Or trash it. Yeah, it's a trash. Trash it. I'm on that side. Confusing. Yeah, it's too confusing.
I don't know, we do have pictures of the gun.
Uh-huh.
But in case the juror, for whatever reason, they want to see a certain gun.
Then y'all will have to wheel it over and we'll display it in the courtroom.
So we can't keep it up here while they're delivering.
No, mm-mm. No, I mean, they might deliberate for a month and a half. We might need to I'm going to be using this courtroom for the other defendants in this indictment. So, no.
Your Honor, Ms. Pershfield, these are, I separated these. This is investigator Dennis's stuff that was taken out. This is
Okay.
the Jimmy Winfrey, plea that was taken out.
Okay.
And, a transcript for, Mr. Sledge.
All right.
So these are all different things that were either removed methods, whatever it is.
They're not.
Can you make sure that 444Y and 1AS are not going back? They were, I think maybe Ryan, I don't know, something to do with, no, I don't know what they were. I just have a note to myself that those are continuing witness.
This is a hot mess.
Your Honor, I've looked at the revised indictment that we just received, and it's acceptable to me.
Thank you.
Guys, do you know where wire?
Why should be in the court in there?
That may have been Mr. Sledge's pleas or something like that.
Yeah, it works. See it, it's right there? You cover it, sorry.
What was that number again online? 444?
All right. So family members,
Weinstein has it. You looking for
turn this down a little. Family members for Shamel Drinks and Donovan Thomas just arrived to the courtroom. Young Thug's dad is also in the courtroom sitting next to Diamante Kendrick's mom. That's update there from Joseph Papp. But keeping this on screen so you guys can watch what's going on in the courtroom.
The real tiny piece. My traveling.
Shout out to Chris Hayes out here sniping with the gifted membership. Show Chris some love in the chat. Sniping through all these evidence cards to get somebody slimed green. Yep, Gordito, a lot of this evidence will be used for the next trials, which is a little crazy. It looks like it's like open and could be rolling around, but okay. Shout out to Angela M21 for becoming a new member. Cute picture. Tommy Nolan says ESPN is gifting turkeys to the jurors today. Is this the sports network or every slime play nasty? Because I don't know if I'd want a turkey from the second one.
I do not see one AS in here. Okay. Oh, you know what? It's the same thing.
Oh. Okay.
Okay, so we don't have to worry about that.
Okay.
I don't know, I don't remember.
Right. For Always Forever for Life says the jury's probably furious. Why didn't they do this on a non-jury day? That was a loud squeak. Holy moly, Atkins. They might not know exactly what's going on, but you sit there, you kind of
Right, and I'm just
fester
gonna
in
put on-
frustration, right?
Ms.
I'd
Taylor,
imagine
I'm
they're
gonna put on the
antsy.
record that I realize if you put on the record for me, put on the record for me.
Okay.
Give me a second.
Okay.
All right, so 1AS that I referenced before, I've realized that is the exhibit number from Mr. Sledge's plea, and it's not the exhibit number for this trial. The exhibit number for this trial is 444Y. They were just the same thing.
Oh, that was the plea.
Yeah.
But the 444Y would stay in there.
It's in evidence, but I don't think it would go out.
No, that came in because that was back and forth about. What was the other number that you were concerned about? Because they're looking at.
They're the same. No, that was it. It was 1AS, but that's not an exhibit to this trial. So it was just the way that exhibit was referenced in Sledge's agreement. So don't worry about that at all. Okay.
I had one there somewhere.
Yeah. Okay.
This is so much like chatter. The chatter is starting to get to me. Mocha is me says, Floyd, I have 2 points. You are not a RICO expert, so sit.
All right, I think, I mean, if we're ready to start wheeling it in, we don't have to have all 5 things at once. We can wheel in number 1, carry in number 2.
You ready, Judge?
I am.
Ready?
He wants the verdict form.
They're all right there, in the middle, right there, yeah.
Here they go. That's all of them right there. That's everything. Oh, is that in here? Wait, it's not. The indictment is not there.
I'm imagining like a bar rescue show, but it's court rescue and it's Paige getting people in line.
With the printed
What's
out.
the holdup?
Yeah.
Yes, Jim, this is how the sausage is made.
All those demonstratives that are right there go? Okay, thank you.
Thank you, Judge.
Those overt acts are out. They're
This
redacted.
is
They're
just for
deleted from the
purposes
indictment,
of
Red
the
Bunny.
record.
Okay.
The state has reviewed the revised indictment, and it's going to be printed. I was just going to put for the record that the state, would object to the removal of the 133 counts, overt acts.
The ones that Red Bunny
are
is asking about.
174, 75, 189, and 190. Thank you, Your Honor.
Womp. Womp womp.
Is that ready right there, guys?
That's not going, yes.
None of that's going? What is it?
She's waiting for the
Document evidence.
Yeah, Sandra Sublet, I agree. The defense has to watch them because they're so dishonest.
These right here?
Ensure that they don't include evidence that was excluded. Sleight of hand, shaking my head. Wash love's hands.
All this is ready?
That's the coverage.
And I think Sharp pulled together like 3 or 4 things. Like, hold on, take these out.
No, there? Oh, okay. What happened?
So what?
They're over there. They're over there. LT.
Yeah, I don't know what the court reporter is transcribing. Maybe just. I don't know. Maybe she's just working on like whatever document for like exhibit numbers or whatever for taking over custody.
Look, there's so much more room.
Do you guys want a 60 seconds all caps? Everybody's just going to be yelling mess and chaos.
I'm gonna double check on my list.
None of that? What else? That's it?
No, I have a few things, but we're waiting.
Okay.
Oh, they're sitting down, guys. They are taking seats.
I just figured I kept all that together.
All right. And a big shout out here to Mama D, gifted 5 memberships. If you guys don't know what to say with your all caps, shout out to Mama D.
Thank you. Just
Show
in case
some
we need it.
love. Super nice of you, Mama D. Thank you for supporting the
Leave it back
channel.
there. I don't know where anyone is. I guess put it, you can take it into the jury room in case they reuse it.
Yeah, I'll let you know.
All right, while the jury is deliberating, Ms. Persfield's going to check to make sure she has a cell phone number for each of the attorneys, because obviously we have no idea when and/or if they might want to ask a question or look at evidence, and so we all need to be on standby. We're all still in trial, and I need for people to be able to get here, in 5 minutes' time, ideally. If you have a special place you need to be, we can talk, but in short order. And obviously, the defendants will continue to come over each day that the jury is in deliberating, so that they can also be available to come to the courtroom if need be.
I apologize if the court has already stated this. When will the jury end their deliberations today, and what is the schedule for them tomorrow?
Oh, it's in what time?
Yeah.
Well, I have instructed them through the deputies that they need to stay at least until 5. If they want to stay beyond that, they're free to. Not past 7 ever, which I don't think they're going to want to anyway.
Oh, yeah, going back there. I haven't done that before, did I? It's scanning.
I think the printer's going bananas. You hear the printer noise?
All of this is like almost done. I'll bring it up. Because I'm reading too fast. Yeah, I was like, I don't know what's happening. I know.
All right, and so they would like to continue to come in and start at 9, which is fine with me. So I'm going to say, just like a regular day, 9 to 5 with a lunch break. There will be days that the court provides lunch for them, and on those days, they can choose to deliberate during their working lunch if they want to, or they can not deliberate and just take a break and eat. I'll make it clear that they can only deliberate when all 12 of them are there together. With regard to tomorrow, since it is the day before Thanksgiving, I'm going to say that they can leave at 3. And other than that, if there is some day or time that we need to alter that schedule, we'll just take it up as it comes.
And if they, I don't mean to ask for such detail, but if they decide to stay past 5, will we be notified of that so that we know to stay around the courthouse after 5? Or if they decide to stay after 3 tomorrow, will we be notified of that? I just want to make sure I don't leave the courthouse if they decide to deliberate late.
Sure.
If I have cell phone numbers for everybody, I'll do a fun group text chain and then text everybody what the schedule, what's going on, very briefly.
Thank you.
No, Friday was already scheduled as a holiday date a long, long time ago.
Bots.
No.
May I approach?
On the record, off the record.
I'm gonna make sure, but let me do this first and then I will.
Oh,
Yeah,
Oh my
exactly.
God, that's hilarious.
they can stay until at least 5. Can stay till 7 if they want, but not later. They can leave. Oh, Law and Crime put up a verdict clock. Deliberations didn't officially start, and they're saying an hour. Oh, it hasn't actually started. I feel like this isn't actually moving because the seconds aren't moving. So we'll see. All right, 1 minute, 42 seconds. There we go. We have an official timer. Shout out to Law and Crime. And they can leave at 3 tomorrow because it's the day before Thanksgiving. They're supposed to come in at 9 each day. And typically at least stay till 5, but they can stay later if they want. So, there we go. I don't know if there will be anything else more interesting, but they have the attorneys sitting here, so we'll hang out and we'll listen and see. We'll see if they come back with a question right away. Yeah, everybody clap for the verdict clock. We're officially here in deliberation time.
My printer decided to be crazy.
They have a mind of its own.
Apparently.
Candace Yates says, wow, I can't believe the jury's been waiting. Yeah, we almost needed a waiting clock there for sure. Good to see you, Candace. Garrett S. says, state hit the ball on purpose. Intentional delay of game to run out today's clock. They know a quick verdict is not helping them. Tell me I'm wrong. I agree, because they even argued in their closing. You've got to go sit there and consider all the evidence, look at it.
Oh, no, I get it.
We want you to look at all of our spaghetti. So, I definitely agree. I don't know if they were intentionally hiding the ball with this evidence cart thing today, or if it's just been unorganized the whole time. I would say probably, you know, maybe a little bit of both, but certainly that they've been unorganized this whole time. Thank you so much, Garrett. Touche says, well, this case has been a consistent disaster from start to finish. For sure. Holy moly. No. Do you guys have predictions on jury questions? I think we're going to get jury questions. The instructions might be a bit short, but it's a complicated task on their shoulders, right? The co-conspiracy, was it knowingly and willingly? What if it was one person that's not in this room? I do expect some type of question on the instructions. As far as a question to review certain exhibits that might not be playable in the courtroom, like maybe videos can't be played, I think they might come out and look at that in the courtroom if they have to do that in Georgia. But other than that, I don't know. Jenny says group text, woohoo, everyone loves a large group chat. They're gonna be in there like, hey, just so you know, I'm not acquiescing just because I'm not responding. Hilarious. Gary Indiana says, just get the jury their slime drink already. Can you imagine if they requested that?
That is everything. The jury has the case, and we are in recess until such time as we hear from the jury.
Okay, so is this technically minute 0? Or are they going to keep it at 5? All right. This is a weird moment. Isn't this a weird moment? Like, this is it. No more from the attorneys. No more arguments over instructions or evidence. Just the jury, and just waiting on the jury. So.
But yeah, and that way, if there is a question,
And we'll see. It seems like they might keep this verdict clock, so if we want to be technical, I guess maybe we can just minus 5 minutes from the total time here. Tommy Nolan says Viverito's jewelry box requested by jurors to view. Can we view this in private? No, I don't think so. They just want to see the watches. Ooh, what if they get to examine the jewelry evidence, right? I know they're not sending that back with the jury, but just go down this hypothetical ride with me. Then one of these jurors becomes an expert witness in a future trial because they looked at a watch one time and they can say, now I'm an expert. I held it in my hands once during a case I sat as a juror on. Just like Viverito did with her excellent ability to identify Glocks in a screenshot from a Snapchat story. Good times in this trial. Shout out to Candace Yates. Candace says, hey, good to see ya. Of all the juries I've ever sat on over the years, we never had to wait for evidence. And I do think this is a little unusual because there's probably a lot of evidence, but there's a lot of evidence in like trials involving finance, right? Civil stuff, paperwork. So I don't really think there's an excuse to not have this ready. At least Atkins is all in the camera. That'd be like if I did my stream sitting like this. But yeah, that was a lot. That was a lot when they ended court early on Thursday to give the attorneys time to go through this evidence. It's something that they specifically ended early to give them time to do. So how did we get here? Business as usual for this district attorney team, this prosecutor team. Just a hot mess. Let's see. Thank you again, Candace. Jennifer Devine says Paige is gonna need an emotional support dog too. She is like on it. I'm not kidding about the bar rescue metaphor. If there's a court that's not running efficiently, put Paige, have her shadow over someone and just tell them to get their act together. Let's see. Sandman, good to see ya. So the jury is now going to get this unorganized pile of evidence from mostly the state, a true clown show. I'm telling you, they're putting the spaghetti back in the deliberation room there. You can throw it at the wall yourselves if you want to, jurors. Like, that's what we're doing. A whole potluck here. Here's your working lunch meal. And then let's see. I think they typically keep the feeds up when they do these juror clocks. I'm surprised they... you know what? The deputy probably told them to cut the seal. Maybe they'll get a backing logo and they'll put up an overlay on the screen. But from other trials I've watched, they typically just let this run live and they just come back on screen when there's a question. To explain again, in case anybody's heading out, we will be wrapping up this soon unless there's a question right away. I will go live when there's a question or a verdict or a note that we can't come to a unanimous decision. Essentially, anytime court's going to come live and call the attorneys in, call the parties in because something's happening with the jury, I will pop on live as soon as I get the notice. So make sure you hit that bell, at least for the short term, the next few days, if you want to get those notifications. But as far as, not for nothing, but they could be deliberating for a week. So not going to waste your time sitting up here making it seem like we're ready to hear something. William Fagan, I like this, says, trial by show and tell. Here's a lot of stuff. Please come back guilty. Even if you don't know what it means and we're filling in the blanks for you with inferences or telling you, you know, the only reason they're sitting in a gas station, in the car at a gas station for so long is to verify that somebody is wearing the same sneakers and that it's the right person that they're planning to shoot. Not because they just bought a backwoods and want to roll up before they go to the studio. You know. Carrie H, thank you so much. Carrie H is gifted memberships. I'll get Carrie H in this banner here. Good to see you, Carrie. Make sure if you're getting a gifted membership, always have some manners, say thank you. I gotta update this count. Always off on my count here. All right, so we've got an updated banner. No more chair squeaks until something happens. All right, we've got a justice-y moving background here. Look at Law and Crime doing it big with the video background. We got something to look at. Like it. It's a little stream decoration. But thank you again here to Carrie H. Got you in the banner. And also big shout out here to Janky Grandpa. Also just got you in the banner. Grandpa's here. Janky Grandpa's here. Giving us 10 gifted memberships. Don't know how you got the name Janky, because this doesn't seem janky. So big appreciation here for Janky Grandpa as well. Let's see. Yeah, we can do a poll. We can do a poll. What are our options? And this is about what you think the jury will say. So try to vote what you think the jury is going to do, which might be the same as what you would do. But remember, that's a slightly different question, right? So what do you think the verdict, the jury is going to come back and say? Jury will come back. Let's see. And when I say split on counts, because there's a character limit here, split on counts means they find guilty on some counts, not guilty on other counts, right? It's not just straight across the board. And then hung. So there we go. Poll is live, you guys. So if you feel like voting, go ahead and vote. We'll run it for a few minutes. Thank you again to Janky Grandpa and to Carrie H for the nice gifts. Ike says, jury questions. Conspiratorial overt acts without count one. Yeah, can you imagine if they find, like, they write down an overt act, but then say not guilty on the counts that the overt acts are related to? Like, just a whole mess, right? There are certain tells. Maybe the jury collectively, if they did something like that, maybe all 12 of them agreed to troll. But I think something like that would suggest that this is a confusing hot mess. So, who knows? I think anything is possible. Tommy says, we owe a huge shout out to this judge, seriously. And I know that people have valid criticisms. I know, like, even I'll sit up here rolling my eyes at times. I am very glad that she kept those overt acts out. The state really tried to say that this case law was fine. Oh, wait, the poll's broken. Hold on, it says 414 votes. Poll, not polo. Okay. Yeah, I think YouTube's just being funky. YouTube updates something on the back end every couple of days and things always seem to break somewhere. But yeah, I think, you know, this judge getting it through, I think it was hilarious that she said, I'm not saying there's any reversible errors. Definitely a wink wink moment, because she said other times throughout this trial that something could be reversible. She very recently and pretty explicitly stated that a previous ruling by Judge Glanville, I think regarding the Jimmy Winfrey plea, was whoops. So, you know, what she said today, I think, was she just didn't want to make an assertion out loud. But it seems like she's thinking that there's a likelihood of a certain appeal outcome if it goes there. Let's see. Is the poll working for everybody? I mean, I do see a bunch of votes coming in. So I do think it was just a lag on displaying as you guys are voting. But it says there's 550 votes. Interesting, right now, currently 11% say hung. 11% say hung. And 51%, it just went to 51, say not guilty. Right? So... we're just watching these numbers roll in. Shout out to Sonia Hart 83 for becoming a member. Thank you so much. And yeah, I don't really know if I predict a quick turnaround. I do predict questions. Because it's just confusing, you know? Let's see, anything interesting over on X? Take a quick peek. Okay, so they are giving a 232 timestamp. So, yeah, this looks ahead then. This law and crime looks ahead. Because 232 would have been like, well, time is going as I'm reading this, but it would have been like 13, 14 minutes ago. I mean, 12, 11. So I think that 5 minutes, shave that 5 minutes off. Anything else interesting over on the Twitter world? And then there was something interesting that here. I didn't really hear it said, and I miss things when I'm on stream sometimes, but Joseph highlighted that Whitaker just said that the jury might be deliberating for a month, and he notes in parentheticals here, which seems like an extreme exaggeration. And she will probably use this courtroom for the remaining 11 defendants. So remember, on Tuesday, we're going to have the status hearing for these remaining co-defendants: Khalif Adams, Damon Blaylock, Javaris Bradford, Christian Eppinger, Miles Farley, Javon Fleetwood, Demikian Garlington, Demise McMullen, Tincurius Mender, Jaden Myrick, Jimmy Winfrey. Justin Cobb was in the indictment, but he hasn't been arrested. He's like on the run. So that's why this is listed separately here, that he's not in custody. And let's see. And he also noted that it seems like they expect the jurors to deliberate for days. So that's just a sentiment check, a vibe check there from Joseph Papp with AJC. SteffJK says closing time plays in the background. Oh no. Ike says, bye everyone. It's been a pleasure. Be safe. God bless you and happy holidays. Ike, see you around somewhere, buddy. Thank you so much. And also if you guys are getting together, I know Thanksgiving is a big travel holiday. People go and see their family here in the United States. I always love it because it's food, right? Food, family, friends. So I don't really have plans. I like Zoom conferencing with my family when they do their dinners. But everybody enjoy whatever you're doing this week, even if it's just a regular day. Hope everybody has a good one on Thursday if we don't get back together tomorrow. But yeah, it's really been a pleasure to do this with a great chat. And again, all love to the mods. Because without the mods, this chat could very well suck. So, shout out to the mods. AK says, going through the evidence and laughing about allegations of stealing bothered me because they know it's a real issue. Lots of theft in this case. So, I feel this, and this could be it, but I do think she was laughing at Hilton for suggesting as an example, like, oh, things that we might need to get, the physical evidence that we might want to put in front of the jury, like the jewelry. And I think Paige just rolled out of laughter with a, haha, why would you want to put the jewelry in front of the jury? Why would that look good for you? So I think because of her body language and her nodding her head, I can see why it comes off as her laughing about the allegations, as if the allegations are just so far left field. But I think that was the way she was wording to Hilton. That would be a stupid thing for you to want to put in front of the jury. Why would you suggest that? That's something the defense would suggest. So, but I see, you know, her language, her body language was very much like, ah ha ha ha. So, and either way, no matter what the judge was thinking, oh, you're thinking the way the state was laughing. Maybe. My bad. I mean, either way, I think it was a dumb suggestion. Well, you know, when you think of examples on the fly, maybe Hilton was just thinking of something, and that's what she blurted out, but yeah, you know. Let's see. I'm going to keep flipping back and looking in case you add to this 8K. Thank you again. A Skywalker says, thank you for the hard work and dedication. See you at the reunion, the verdict. Heck yeah. We're going to be here. Hit that bell notification, you guys. I feel weird saying that because, like, it's part of, like, some people's spiel for every stream. And, you know, I don't care. If you guys tune in, I appreciate it. If you guys don't, good to meet you along the way. But if you do want to get that notification for a big moment, this time I think hit that bell. So yeah, see you then. Okay, Grammar's out here dropping 10. Hold on now, let's get some eagles in the chat. Got to update this banner as well. And it's so funny because there are times where I type grammar with an E now because of K Grammar, and I'm like, oh, someone's gonna make fun of me one day, and I'm gonna tell them the great story of the Honorable K Grammar. Get you in the banner. Thank you so much for gifting 10. Super nice of you. Oh, yeah. No, you could hear that in kind of like a few moments. They were just like so giddy, golly hoo-ha, while they were going through that evidence. And you might have been talking right at one of the moments where like a body's forehead was leaning into the camera. Maybe Miss Knight? I don't know. Someone's head was just in front of the camera here. But yeah, just a jolly good time while we're way behind on everything that we should have had done already, and hot mesticle. And thank you for showing love here to K Grammar Chat. Love you guys. And I don't know, what do you think the first thing that the jury's saying back there is? Just whelp? That'd be my first word. Oh boy. Touche says, Kat, it's been a pleasure. Thank you. No, thank you, Touche. another person definitely great to meet. And again, I'm so excited to play, like, on those road trip games, you can like mark off when you see certain landmarks or whatever. Like, I can't wait to be out here on YouTube trying to see you guys here in other chats somewhere, like other hobbies, like in cooking chat. Well, does the YouTube cooking community do many live chats? Those are usually like pre-recorded, like on demand, right? So, but I would love if there's like a channel out there. I'll see you in like a cooking live stream somewhere, you guys, video gaming. We'll run into each other, and I'll do more content. I just don't have specific cases in mind besides the Courtney Clenny case. And the YSL, the continuing YSL indictment, whenever that trial kicks off. I think Paige is going to set a date, though, because it's Paige. Whitaker's like, let's go, people, let's go. So we'll see you around, Touche. Sheriff Chuck says, check with family on guns and drugs before going. Yeah, don't go to your Thanksgiving party without seeing, guys, gotta wipe your feet at the door, bring something to eat. All right, well, I'm bringing something to eat, and I gotta ask you, am I gonna have a constructive possession issue if I'm here in this house while I'm visiting and hanging out? Oh man, this trial. Sean Turner says, what if Shannon or Yak is found guilty? Do you think they would fault Doug or Max? Do you mean, like Shannon or Yak themselves? Probably not like internally, but hey, if there's an appeal argument to be made for ineffective assistance of counsel, you make that argument. Like, screw trying to, and I'm sure Shart and Weinstein would advise it to their clients. Like, yeah, if there's something that is an issue you could raise on appeal, and it involves an ineffective assistance of counsel argument, go get it. Go get it. So I think if you end up seeing something like that down the line, I don't think it should be a personal slight at the attorneys. I don't think the assumption should be that Shannon or Yak hate their attorneys or think they did a poor job, right? It's a mechanism on appeal, and sometimes it's a very effective one. So, would be interesting to see, though. I don't think we'll get that vibe that they are pissed off at their counsel. KC Dog says, just tapped in, what I miss. So they're finally deliberating after like an hour of them going through carts of evidence and cleaning up things that should have been done already. So, if you missed all day, you can go back and hear the jury instructions. It was only 50 minutes, 50. So it wasn't that tedious. That's 25 minutes on 2x speed. But you can hear some of the final clauses and how they were read. So, and again, I still think it's a little shocking that that was only 50 minutes. There's trials where I've watched that the jury instructions are just like, ugh, drone on, very long. Like one defendant who's got like a few charges, a handful of charges, but I was surprised on that. So, now this would be interesting, Shamrock, Truth, Facts, and Justice. Yeah, put on the argument that they didn't put on a defense. But at the same time, the clients waived that knowingly and voluntarily. So there'd have to be more established there. Why wasn't it knowingly and voluntary that they waived this right to put on a defense? The judge asked both of them on the record. So there's a hurdle here. There's a big hurdle here. I was inebriated at the time when I agreed to waive my jury trial. I don't think that's going to fly when they've been in custody. So it might, things that are typically trial strategy don't really fall under a passable argument for ineffective assistance of counsel. So, AK says, you can hear a body say something about it not being stolen with the allegations, and they laugh. See, I do wish in a way that Law and Crime ended the stream and started a new one for the watch. Actually, since they restarted the stream, there isn't much to go through to find that. But I hate doing stuff like this because I feel like it would take me a long time to play and let it hear because I can't just look for a closed caption or some type of indicator. But if it was Miss Knight, there wasn't that much where she was the one right here on camera. This is where Hilton was doing the hands. All right, is this the end of them being in front of the camera? All right, so let's go back this way. All right, so Adam kind of comes around like here.
Thing we will
so-
be waiting on is
I showed it to them and then they wrote one, I wrote one.
So if you have an indicator, if I should go forward or backward, let me know.
All right, Ms. Percifield has what we think is the final redacted indictment, so with the changes we just discussed, so if everybody can take a look at those, they start on about page, 40 or so. Just take a look at those, confirm that they are what everyone has agreed we're going to do, and then if so, we'll print it out, and that'll be ready to go to the jury as well. At which time, the last thing we will be waiting on is the evidence.
Yes, no.
Yes, ma'am.
How far are we time-wise from getting this to the jury? Perfect. All right. All right, while y'all are doing that, I'm just going to put on the record that with regard to the guns and any other physical evidence that's not going to go out with the jury, for instance, the drugs, the DA is the official custodian of that evidence, and so the DA will remain in possession of that evidence, and y'all need to keep that in your locked evidence room. The court reporter is not going to be taking custody of that, the guns and that other type physical evidence that is not going out with the jury.
I know, right? I know, right? I know, right?
Muted, sorry. I think he says, especially now with allegations of something stolen, I know right, is what she says back.
I know, right?
All right, so this would be, how long is the stream going on for? It's an hour and 26 minutes backwards. Oh wait, it's an hour and 26 minutes for this whole stream. Wait, 40 minutes? It's about 40 minutes into the stream then, I think. I don't know. My backwards time math is not good. So, but because the timestamps are going to be different when the stream actually publishes. So I can't hear exactly what's being said there, but something, you do hear them say that. And she's like, ah ha ha. I know, right? So there you go. About 40 minutes into the stream when this actually finishes, or the law and crime stream from day 167. So, also I pulled up Frandrew P. Diddy says, can we go back and watch Juror 56's letter to Paige? So that was, let's see, let me get this on YouTube. That was at the start of the day on like 156. I'm just queuing it up before I switch over to it so you don't have to deal with me jumping through the screens. So this is a rewind to day 156 where day 156 where juror 56 had an email sent to the court. Okay, I guess I could have started a little more forward. It's annoying to try to scrub when the stream's 8 hours long and try to like start forward.
Trying to find the exact which I have. Really an issue anymore anyway, is that, I mean, we're clear on the Mr. Thorpe can't be testifying about Mr. Stillwell's. So if y'all want me to read that part of the transcript, I will, but.
We didn't hear the first part of what you said.
Oh, I'm sorry. I said, I'm sorry, I'm a little late taking the bench. I was searching the transcript roughs for the part that we had been looking for yesterday, which I found. But I think we're clear anyway on what my ruling is about what Thorpe can and can't testify to, but I'm happy to read into the transcript what we were discussing before, which my ruling was, so they can't have a new witness if they have a witness that they were planning to call back anyway, who is already qualified to testify to this, then they can testify to it, but they can't come up with a new witness or recall somebody that they didn't already have on their list. So I think that takes care of that. But of course we have another issue because we can't have more than one normal no issue trial day in a row. So I have an email from one of the jurors this morning. Interestingly, he sent two different drafts of it. The first says, it's to my assistant, when you have a moment, please relay this to the judge. Good morning, Judge Whitaker. I am requesting to be removed from the current case due to the length of this trial and how the state has handled this case. I can no longer be unbiased towards any decisions moving forward. Yesterday provided a glimpse of how the state presented its evidence, and I foresee another 3 to 6 months with the remaining defendants. Thanks. But then that's not what he really meant to send, because he said, I didn't mean to send this version, not the other one, with a minor correction. Hope all is well. When you have a moment, can you relay this email to the judge? Good morning, Judge Whitaker. I am requesting to be removed from the current case due to the length of this trial and how the state has handled this case. I will be biased towards any decisions moving forward. Yesterday provided a glimpse of how the state presented its evidence, and I foresee another 3 to 6 months with the remaining defendants. Thanks. Now, this is the same juror who a few months back asked to be removed from the case and provided no reason whatsoever. And so I just ignored it. I just said, no, you're not removed.
doesn't work that way. And so I think this is just a ploy to get off of a case that he's sick of being on because it's taking up his time. Obviously, we can have him out and privately, not with the other jurors around, and ask whatever questions we want of him. Willing to hear what anybody has to say about it.
I don't know from the court's perspective if this would be appropriate, but I would have no objection to informing this juror that it might not be 3 to 6 months. And I think it might not be 3 to 6 months or whatever he said. And I think that is accurate and honest at this point.
I mean, I think it would be fair to say we have no expectation that it'll be another 3 to 6 months.
In Your Honor, we understand that he said that he is biased
Towards any decisions, whatever that means.
right, but he said that, but he specifically talked about the state and how the state is cleaning up its case. So therefore, the state would have some concern with the juror not being able to remain fair and impartial, given what his language was. He didn't say to either side, he said specifically to the state.
No, he didn't. He said, I will be biased towards any decisions moving forward. Yesterday provided a glimpse of how the state presented its evidence, and I foresee another 3 to 6 months with the remaining defendants. And frankly, you have to start a case unbiased, but as you listen to the evidence, as long as you don't deliberate with anybody, you can mull the evidence in your own mind. And frankly, if y'all are presenting the case in a way that is driving a juror crazy, that's on you.
And I understand that, but if he is, it appears that he is, his thoughts at this point is that he's, and maybe that's what we need to ask him, whether or not he still be fair and impartial. Watch everything outside the presence of the other.
I mean, I certainly think that would be appropriate.
Remember, the day before this was when Wooney Lee got back on the stand after the plea deals, and they, as soon as Wooney Lee was done, they brought up witnesses to talk about the Jamari Holmes murder.
So I'm looking for some kind of the general language that we give about needing to decide the case based on the evidence. So once I find that, we'll get him out, and y'all can ask whatever questions you want.
And when that is complete, Your Honor, before we bring the whole jury out, I just want to say something to the court, put something on, briefly on the record.
Okay, about this or something else?
Something else, it can wait.
Okay.
Thank you.
And the day before this was also when we had Detective Stormo. Stormo. He was asked about that watch. So that's what happened before this email was sent. Let's get to the part where they bring the juror out. Hear his answer in court. I broke it. I broke it. All right. Come on, YouTube. Do they stand for the juror when he comes back in? All right, let's do here. All right, here we go.
Good morning.
Good morning.
So I am in receipt of a correspondence from you this morning. And I'm actually in receipt of both versions of it because you sent one and then you adjusted it, and my assistant had already sent that one to me, so I have both. And you seem to be expressing concerns about the length of the trial. And I've discussed that with all of the attorneys, and we all feel comfortable representing that there is really, it's almost certain that this trial will be over far before 3 to 6 months have elapsed. I think it is probable that it will be over before the end of this year. So I'd like to find out whether that assuages any of your concerns.
Given that you say probable, and I'll keep it as is, but I will, if it prolongs, then I will send out correspondence and if it goes into 2025.
All right. Let me ask you as well. You said that you, first you said you could no longer be unbiased, and then you said that you would be biased towards any decisions moving forward. Is that because of your worries about how long the case might take?
Yes.
Okay.
I projected when we first began this entire case, we were projected to be in 6 months, and it was to a year.
Yeah.
And then given the circumstances in between, I just personally, I just feel like it's just too long.
Yeah.
You know, I love what I do for a living. I miss what I do.
Yeah.
And it's been hindering a lot of things with family and friends. And
Yeah.
things. And so since you used probable in the sentence, and so therefore I can you're assuring that this will probably go toward the 2024 year, so then therefore I can still stay on board.
Okay. Let me ask you a couple of other things as well. I know that you were instructed with some version of entering the case and considering the evidence with an open mind and not reaching any final conclusions until the trial is over with. Can you continue to assess the evidence with an open mind?
Given the information that we just discussed, then yes, I can.
All right. Okay, and can you decide this case based only on the evidence that is presented in the law that I give you, and not on whether you like or dislike anybody's presentation style?
Since you work that way, then yes, I can go along with that.
All right.
Shoot for 2024 just to be.
All right. Do any of the attorneys have questions for this juror?
I do not, Your Honor.
All right.
I do not.
No, Your Honor.
All right. Thank you very much. I'll excuse you to the jury room, and we'll have y'all all back in just a minute.
Okay, and then also, hold on, I'm going to jump back over to Verdict Watch stream because one more little surprise from day 156. You might know what it is, but let me cue it up. Let me cue it up. All right. All right, you guys ready? It's real quick. It's real quick.
Thank you. You'll swear on that witness?
Raise your right hand. You swear firm testimony you give the truth, the whole truth, nothing but the truth?
I do.
That's it. All right, state, spell your first and last name for the court. To the mic, please.
Yes, sir. Detective J. Thorpe Jr., Thorpe.
And good afternoon, Detective Thorpe. How are you?
Good afternoon, ma'am.
I want to welcome you back. And I want to really direct your attention to March of 2022. Have you been assigned the homicide investigation of the death of a Christian McMiller and Darius Ford?
Yes, I have been.
And when did that homicide occur?
It happened March 11th, 2022.
And where was the location of that homicide?
It was 7585 North at Fair Street, City of Atlanta, Fulton County, State of Georgia.
And is that still an open and pending investigation?
Yes, it is.
Thank you. I have no further questions.
Any defense questions?
No questions. No questions.
All right. Thank you for your
let's watch
time.
him
You
walk away.
probably are our fastest witness yet.
Yes,
You are
ma'am.
excused. Call your next witness.
A whole trial, a whole trial. No, this is Thorpe. This is Thorpe. The official squirrel brain, although the name has carried to others. Well, I want to make sure I got a question right, talking about jury and sticking it out. Was it about staying on the jury? Oh yeah, okay, was staying on the jury. Yep. If I was called for jury duty, I think I'm in a very fortunate position. Well, maybe that's not correct wording because I'm about to say I don't have any kids. I don't mean that not having kids is fortunate or unfortunate, but I don't have kids. I don't have like health needs that I have a pre-planned surgery that I'm waiting to get in 6 months, and a long trial could interfere with that. So I think I'd be able to get past the hardship burden bundles and sit there on a longer trial like this. Really any case. So that was a question raised in the chat here. Could you sit if you were a juror? Would you stick it out? Right? So I think that's an easier question for me to say yes to, because I don't have to, a year where it's impacting my kids' lives, I don't have to have that question on my shoulders. Stuff like that. So, but yeah, there was this freeze frame of Paige here is kind of great. But yeah, shout out. Thank you, Fran Drew. Can we go back and watch Juror 56? And we also got this guest appearance here, this quick appearance by Thorpe. Cannot wait to hear more on that. So stay tuned on the Thorpe thing. Nicole Blevin says, Kat, your voice is so soothing. I'm glad you think so. It doesn't sound the same to me, I think, as it might sound to you guys, because I'm like, ugh, me talking. But thank you so much. Tommy says, love. Oh, we'll get back over here just in case we're not missing anything, I promise. You can hear a body say something about, oh, I'm reading AKs. Tommy says, love's voice is my op. Like nails on a chalkboard. Yeah. That's what I mean. I think Hilton was way easier to listen to. We asked at the beginning of the chat, would you rather listen to Love or Hilton for 2 hours? Because there were a lot of, the criticism, the focus has been on Hilton because she delivered closing statements. But I was like, would you rather Love? Would you rather Love give that same delivery? So, with Love, I feel like they would have continued closing today. They would have had more arguments to go. So, let's see. And Melissa says, absolutely worst prosecutors ever. I like the brevity here. Short, concise, clear message here. Love it. Thank you so much for being a member. Let's see. As far as like watching stuff, I don't know. There is a small chance. I don't really want to say small. There is a chance for some unknown period of time I might pop up and we can do some rewinds or just talk about the trial. But as far as today, sitting here, I think it will be, if there's something happening, I will start a new live back up. I'll go live as soon as I hear there's a question or some type of note coming in from the jury. And we'll get together. We'll act like the attorney is rushing into the courtroom. But as far as, I'm sure somebody's got to be doing something right now. So is there anywhere you guys would like me to send everyone to as we wrap this up? And also tonight, today is Tuesday, Flesh of the Gods is going to be doing YSL content tonight. It's probably scheduled. Oh, he's live right now. Oh my God, let's go over there. Guys, we're going to go on a tour he's covering Hilton shenanigans. So we're going to go over there now. Oh, this is cool. He's doing a daytime stream. He's usually late night. So here's a link here. Oh my gosh, I can't type. Flesh of the Gods. All right, so, and we will redirect over there, but, putting the link in there because just in case. And I see Sapphire Ridge News says he's going to go live at 4 p.m. And I see that the last thing you're talking about here is YSL trial goes to jury. I don't see your 4 p.m., so I'm just linking to your channel here, Sapphire Ridge. But, tentatively, you'll be going live. 4 is about an hour from now, right? About 40 minutes from now. And I think you're using Eastern time zone, right, Sapphire Ridge? It might be an hour and 40 minutes from now. So either 4 p.m. Eastern or maybe 4 p.m. Central. I forget what time zone. Don't know which one you're using. But either way, link to his channel, Sapphire Ridge, is in the chat. And we'll go over, we'll just like take the party over here, over to Flesh of the Gods. Gotta give out some memberships over there. Make some people green. Let me set up this redirect. This will be fun. Take us on a trip to Flesh of the Gods here to watch Hilton's shenanigans in closing. And in secret, I'll be taking you all on a trip to the kitchen with me because I'm going to start doing some food prep for the holiday cooking. So we'll get over there. I'll say hi over in that chat. See you guys in a couple seconds if you come over there. Thank you so much for hanging out, and a big thank you, mods. Am I coming back for second round? Do you mean the other cases? Yes. The other co-defendants? Yes. So, oh, and Sapphire Ridge News says 4 p.m. he's going live, so that's 40 minutes. Thank you. I figured you were using Eastern time, but just wanted to check. So yeah, we're going to go over here, watch some of Hilton's shenanigans. Oh, let me end this poll. What are our results here? Jury will come back not guilty, 55%. Split on the counts, 29%. Hung, 11%. And only 4% say guilty. Like across the board, right? So that's almost 2,000 votes. It's 1.9 votes. So that's an interesting take. I think it's interesting that 11% say hung. And that can be a real possibility. You never know. So only time will tell on that regard. And we're going to teleport and see you guys in 2 seconds over at Flesh of the Gods. Bye, you guys.